um, to receive briefing on the naturalization of the Gupta family by the Department of Home Affairs, and we were expecting the presence of the Director General of Home Affairs, as we missed him dearly last week, and probably comes to actually make good of that today. Then also we were expecting the Minister of Home Affairs, and then as well as the Minister of Finance. And then communication has been sent to them to attend this meeting today, and they have indicated the following in terms of their unavailability. One, the Minister of Home Affairs apologized that she will be outside the country, and she will be a head of delegation on behalf of the Minister of International Relations. And however, she indicated that there will be an acting minister that she will inform to actually act on her behalf. And then the acting minister that has been appointed, the acting Minister of Home Affairs, is Minister Faith Mutambi. But then also the acting Minister, Faith Mutambi, has apologized because of prior arrangements. And then she's not here. And then the Minister of Finance, and then I hereby tender an apology on behalf of Minister Malusi Gigaba, Minister of Finance. He'll be unable to attend the meeting as indicated above due to prior commitments. And then that has been submitted by the PLO. And I hope that that is on the instruction or the communication that was engaged with the Minister of Finance, who was the whole of last week, I think, also outside the country. I think then the DG then has not apologized, and the DG is here. And I think that is the explanation that we have in front of us in respect of the three ministers. Honorable Steenhuisen.
Chair, thank you very much. I'd also like to, on behalf of the Democratic Alliance, submit the apologies of Mr. Hanif Hussein, who's unable to be here today, and that's why I'm sitting in your committee today. Chair, may I make a point in limine before we begin proceedings?
Just a second. And
sure.
Also, I think it's from Honorable Hussein. Exactly just like last week, I think he wrote also a letter to myself that he sought answers. And because even last week I tried to say that it is just better that he presents it in the committee resolves to answer. And then, but the letter, I think I said the secretary must just distribute back to you, honorable members. And then you'll just appraise yourself on the content of his communication. And Then we have got the following in the House. As I've indicated, we have got the Director General of Home Affairs, Kusela Plain, who is here. And then we have got also Norman Ramashia is here. He's the Chief Director. Then we have got Richard Skakane, he's the Deputy Director for Citizenship and Travel Documents. Then we have got David Tlabane, then the Director on Communications, or spokesperson, spin doctor. Then we have got Umuzi Njoko, is here, as well as Umpumi Madlala. They are PLOs. And then we have got Luvuyo Lupondwan, the Assistant Director, is here. Right, and then we have got Patrick Williams, the Chief of Staff, is here. Then we have got Lereng Tsetsana. Then we have got Agnes Kabinde. And then we have got Stephen Zimri, I think the office of the DG in Cape Town is here as well. This is a delegation from Home Affairs that possibly will assist us with all the necessary, the briefing and the explanations on the briefings and the rest. I have not received any apology on the members, on the honorable members. So all honorable members will be here. If they are not here, then we'll hope that they are coming, except for Honorable Hussein, as Honorable Steenhuisen has already raised his apology. Thank you very much, Honorable Steenhuisen.
Thank you very much, Mr. Chairman. I'd like to deal with the point in limine before we begin proceedings, if I may. And that's to say that Section 55(2)(b) of the Constitution says that this Parliament must provide mechanisms for the executive to be accountable to it, for us to maintain oversight of the exercise of the national executive authority, including the implementation of legislation. And while I'm very happy to see a full delegation from the department here today, and we're very grateful for their presence, they do not exercise the national executive authority. That national executive authority is vested in the minister. And certainly on reading the papers and the argument that they've put forward today on the papers, it appears that the department itself has followed the regulations, and that's not why the reason why we're here today. The reason why we're here today is because an executive decision was made by the then Minister of Home Affairs, Mr. Malusi Gigaba, to exercise his executive rights in terms of Section 5(9)(a) and (b) of the relevant legislation, which is ministerial discretion to do so. So unfortunately, I can't hold any of these gentlemen accountable for where this process has gone wrong, because the process hasn't gone wrong on their side. The process has gone wrong, I believe, on the exercise of the ministerial discretion. And that's what we should be doing this morning, is holding the minister, former minister accountable, which is why we asked that he be summoned to the meeting so that he could account for his decision. It's not the DG's decision, it's the actor specific. It says the minister may, the minister shall, not the DG. And so I really don't see the point, apart from us, we can talk around the papers today, but that's really not us fulfilling our responsibility and mandate that's tasked us in terms of the Constitution, which is holding the executive accountable. Furthermore, the fact that the minister herself is not here is also problematic, because I would like to ask the minister whether she's going to exercise her discretion in terms of Section 8(1)(b) of the Act now to renounce the citizenship that's been granted to the Gupta family. And she's not here to answer as to why she is or is not prepared to do that. And so the situation we find ourselves in now is completely problematic, because the people before us are neither responsible nor accountable for the decision that's been taken. And I think it's unfair to both Mr. Apleni and his team for me to put questions to him about what was going through the mind of the minister, what further documentation was required apart from Annexure L, which the letter from Mr. Chawla, which was then used to verify and determine whether in fact amounts were made available or bank statements or proof of investment were given, because he's not going to be able to answer it. And so, Chair, I want to put on record that my deep problem with the fact that none of the executive are here, none of them, not one member of the executive is here to account. And Mr. Frolick's instruction last week was that we would engage with ministers. It was very clear in the press statement issued by Parliament that the ministers, these committees must engage with the ministers. And I really think that this committee, if it's doing its job correctly, would pass a motion or resolution here today expressing its complete dissatisfaction with the minister's absence, and would in fact then embark upon the process of subpoenaing those ministers, which I think should have happened last week anyway, because it's very clear that there's a coordinated attempt to duck out of accounting to this body. And so whilst we welcome the team here today, I don't think they're going to help us very much with the information that we request and the oversight which we need to do. Thanks, Chair.
Let me start with Honorable Gumed, and then you'll follow.
Thank you very much, Honorable Chairperson, and good morning to all the honorable members and our esteemed guests. We are happy you are here, and we are happy about all the information we have received so far. And then perhaps what is in dispute is in our understanding of last week's meeting. Our understanding of that meeting was that we were going to invite at some stage, if necessary, any minister or anybody, invite. And we invite because we assume that whilst something is, we are having a preliminary hearing, we cannot come to a stage where we say we summon anybody. But that is up to our minutes. We have not received our minutes, but our understanding of the meeting was that it was an invitation to people that are busy. And let us remember, it is important for the three arms of government to respect each other. We have to respect the cabinet. We've got to respect the judiciary. If we do not respect each other, I don't think we are going to have a successful country, a country that is stable. So for purposes of stability, I would urge the DA to respect our cabinet. They've only been elected by people to lead this country. So I'm not saying that I do not want the ministers to come, but I'm saying let us first get all the information. The DG was supposed to be here last week to give us that information. He could not be here last week because he was attending to other matters in the National Council of Provinces, which had been scheduled some long time ago. So really, let us just take each step at a time, but with mutual respect. Parties should respect each other, but also Parliament has got to respect the cabinet. Otherwise, really, we are not going to have a stable country. We respect them, we do not fear them. Thank you.
Honorable Dambuza.
Thank you very much, Honorable Chairperson. Good morning, honorable members, and Mr. Atlin and your team. Chairperson, I would like to comment on what Honorable you know, it's very difficult for me to. Yes, I'm sorry for that. John. Okay. No, what I want to say, Chair, in our previous meeting, we requested that the meeting be postponed because we did not have information at our disposal. So that was the reason why we requested postponement of that meeting. And now we do have the documents in front of us, and we did have an opportunity to read these documents. But we need to interact with the department in terms of the information that has been provided before us. And thereafter, if we feel that there is a gap from what we have received, the responses that we received from the department, and then I think we still have an opportunity to have another session. In terms of the ministers that are not here, I would request that the honorable members really, the minister, the acting minister, we must really agree that even if she did come here, she would not be able to assist in terms of these documents, I mean the interaction of this information. But for the Minister of Home Affairs, if we remember very well, this has been a long planned, this 27th day, and we received that. At least let's give them another day. We request the chairperson and the whip to interact with them so that whatever we have discussed here and then the outcomes of this meeting, they are invited to come and respond. For the Minister of Finance, we have got a right as Parliament to call anyone to come before the Portfolio Committee to account. But in his case, I think he is the one who has got to give the evidence of what has transpired in the whole process. So I think let's not rush to call him. Let's have a proper information, and then we identify gaps and so on, the weaknesses. If there are any weaknesses, we identify those, and then we call the minister to come and give evidence on what transpired. Thank you very much, Chairperson.
Thank you very much, Kekan. Right, Honorable Mulder.
Yes, thank you, Chairperson. I really feel sorry for my colleagues from the ruling party because they are in a very difficult position. They have to try and save face in the sense. There's no doubt what we decided last week. There's no doubt what we discussed last week. The only thing that was in doubt last week was whether we're going to invite the ministers or we're going to summon them. That was the only question. There's no possibility that we said we need some information and we're going to get some information, and maybe at some later stage, if we maybe need to talk to them, then we will invite them. That's not what happened. If you look at the agenda of today's meeting, why does the agenda then says, point 3, briefing by the Ministers of Home Affairs, Finance and the Director General? There it stands quite clearly. Why would that be on the agenda if that was not the intention of today's meeting? The intention was quite clearly that those ministers would be here today. There was a statement issued by Parliament itself, by the Communication Services after our meeting of last week, and it clearly says the Portfolio Committee on Home Affairs has resolved to invite the ministers, the former Minister and the Director General of the Department of Home Affairs to give facts on the naturalisation process of the Gupta family. This meeting is scheduled for Tuesday next week. That's today. So there's no doubt that that was the intention. The only thing that was in contention was, are we going to be kind and invite and respect the executive, or are we going to summon? Now, clearly we did invite, because we received letters back from the executive saying why they could not act on those invitations. Those are the facts. The problem now, Chairperson, is if that is the case, that the invitations are not taken up, then we've got only one option left. We have to summon. We are instructed in terms of the Constitution to do oversight of the executive. We cannot do that. I respect the officials who are here today. We've got all the information. Fine. Then it will take a little bit longer. Then we'll have to spend today going through the information, but we can all read. We can do that at home as well. But we can do that, we can interact with the officials, and they will give us their take on what happened. But in the end, it's the executive that took executive decisions. They have to account. And it's good and fine to say that we should respect each other. I accept that. But maybe it's time for the executive to start respecting the House of Parliament, because that's not what's happening at this moment. So all I'm saying is, there's no doubt it was a question of invite or summons. So we invited, it was not taken up. So now I suggest we summon, and if we have to do it next week, then to do it next week. But the quicker we do this, the better. Thank you.
Figlen.
Thank you very much, Chairperson. Chairperson, I'm very disappointed. I'm not going to repeat what my colleague said, but if you look at the letter that was written from the DA, it was inviting the Minister of Home Affairs, who's now a finance minister. Again, the minister is invited. There's an apology. Now, really, it seems as if we're playing hide and seek, or we're trying to cover for the ministers. Reading from Mr. Kumede's statement, we don't need to blame one another. We've got the right to do oversight. And if we invite somebody in the meeting, that person has to come in. So I just want to echo some words that we are not fighting here. We want to deal with the issues. Thank you, Chair.
Honorable Mkalibi Hlope. Yeah, one of those two.
Thank you, Chair. Yeah, I just want to add on what my colleagues have said, just to state that shame to ANC now. They are changing their languages. Last week, as committee members, we took a decision united as a committee to say, in fact, let us invite the minister, the former Minister of Finance, and the current Minister of Home Affairs. Let me just remind you, Chair, because it seems as if the ANC have short memories. Chair, last week, correctly so, you reminded the committee that this issue of the naturalization of the Gupta was discussed on the previous meeting. As a result, we asked the DDG, who was present at the time, just to comment on the issue when we were discussing the immigration policy. And the DDG said, no, he is not going to answer because the DG of Home Affairs is going to issue a press statement. Then we took a decision in a committee, we can't be addressed through media statement as the committee, so therefore we need a DG to come and clarify some of the issues regarding the naturalization of Guptas. But last week in a committee, all of us, I want to emphasize that, all of us, we took a decision to say it won't be enough for only the DG to come. In fact, the former minister, who is a Minister of Finance, in terms of Rule 167, just empowers the committee to summon anyone because this matter is very important. Therefore, correctly so, we got invitation or we got communication from you, Chair, through the secretary of the committee to say both ministers will be here today. So now is the very same thing that happened last week. And we have also raised this concern. In this committee, it seems as if we are not respected as a committee. Because as committee members, we are told, is communicated through black and white to say, the DG will come last week. And then we came to a meeting, we only be told in the morning that the DG is not coming. Again today, we've been told during the week to say, former minister is coming and minister is coming, who is Hlengiwe Mkhize. And we really want her as well to come because she has been making some media statement as well about this matter. And she must come and clarify herself here as a new minister too. So, Chair, we must just clarify the thing with when are these two ministers are coming before the committee. We don't want Mutambi here. Mutambi has got her own thing to go and answer somewhere, not here in this committee. So we must make it very clear as a committee to don't want any acting minister here. It won't going to help us. It's going to waste our time. So it is a good thing that Mutambi decided not to come because he must go and answer in communications portfolio, not here. We don't want her here. So we want Minister Hlengiwe Mkhize, who is the current minister, and the former minister who took this decision of giving the Guptas the early naturalization. Thank you, Chair.
I had a hand from Raputi and then Nisi. Then it will be Kekana and Gumede.
Yeah, thank you very much, Chair. I think there is no one who is denying the fact that the ministers were invited to come to this meeting as portfolio committee. But what is in dispute also, it is the fact that the Director General, as an accounting officer, was supposed to come and brief the portfolio committee. That was last week. Whichever the DG was busy in the NCOP. And in as much as Mr. Hussein, he is busy. He didn't come here, Mr. Yesterhazen, and whatever. What we should do, I'm sorry, I forgot his name. What we should do, can we really be able to take the briefing from the DG as it was stipulated last week? We are not disputing the fact that the minister, they must come and account to this committee. So can we take a deep breath and be able to take the briefing from the DG of Home Affairs, and we must be able to engage with the documents before us. If there are any issues, then we can be able to take this matter forward. No one is running away from this issue. Please, let's take a deep breath, all of us. Thank you.
You still have something?
Thank you very much, Chairperson. I think the DG is the custodian of the information of our department, and he is here to account. Last week, we needed to get all the information from the DG so that we can be able to move forward and have recommendations to guide us moving forward. Maybe, Chairperson, our next step may be calling other members from the department to further discuss the issues that we think are not properly ironed in the meeting. What I would like to clarify, Chairperson, in this meeting is that we are not here to cover up anyone, any member of the executive or any member of parliament. We are here to do our job as members of parliament and also as members of the portfolio committee. Thank you very much, Chairperson.
Honorable Gumede. No, Kakan. Proceed.
Yeah, thank you, Chair. No, it's true that all of us we have agreed, and we are still agreeing that the minister and the ex-minister must come and account. That is our agreement. But you see, you cannot say that why are they not here while they told you that someone is overseas? What are you saying? And what do you want to say to us? Because they told you that this person is not around, is overseas, and if the DG now is here, he must account, but we know that they accounted. The only thing is that he will just give clarity. And if we are not satisfied, there should be another meeting that will clarify the issues. And it's where we will be able to summon the minister and the former minister. There's no dispute here, unless if people, they just want to blow this out of nothing. So, and the last point is that I appeal to all members of the portfolio committee. As last week we agreed that let us listen to DG and then we will take it from there. I think the inquiry is needed. If DG doesn't clarify us to the last point. So, but now please, my colleagues, honorable members, let us take DG and we will take it from there. If we are not satisfied, then we will take a decision. And I think the only decision that we can take is inquiry. That's all. Thank you very much, Chair.
Yes. If you are not, if you don't really watch out, you may talk in circles for the next 2 hours. And then I'm referring to those that are maybe repeating to speak. We may talk in circles because any time when you say a thing, you must expect that somebody will respond to you. Honorable Kenya.
Thank you, Chairperson. I think, Chairperson, I'm also covered.
Okay.
But just to make a point that, yes, of course, we say that we agree, all of us. And we ourselves, we always have, we have an obligation. We know that, and we know that this is in public domain, and it is critical. But I think also we must respect, that's what Honorable Gupta was saying, because the apologies are written here. We ourselves always have apologies, which we take as they are. Especially that we are saying now that the DG is here. And we know that the DG and the staff of Home Affairs are those who really print these documents which are in front of us, which we can need also to zoom in and get clarity on the issues, especially with DG, because DG also signs in these same documents. Now, why don't I also appeal to the honorable members that let us really take it that, let us accept these apologies as they are written. So they are not even verbal, so that we move forward. Thank you, Chairperson.
Should I repeat, Honorable Steenhuisen? Yeah, and then the Gumede speak. Speak, Gumede.
Thank you very much, Chairperson. Chairperson, let me once again stress this. It is very important for Parliament to respect Cabinet, the executive. It is very important for Parliament to respect the judiciary. That is why we have a separation of powers. I think the issue we are about here is that given that the DG could not come last week, we needed much more information. That is why we received this very thick document after the meeting. It did not come before the meeting because of what arose last week. And this document we have read. And then after reading it, we need clarification. We need facts. We need then to ask the DG to clarify further. After that, the ANC is prepared to look at all the facts respectfully. It is prepared to look at all the proposals, so far it's invitations, summons, and this and the other, inquiries and so forth. We are saying we are prepared to factor in those proposals in our response going forward. But we do not want to make decisions prematurely. We value also our relationship with the executive. We value our relationship with the judiciary. We value our relationship with all other parties, because if they were not there, the credibility of our democracy would have been in tatters. Mm-hmm. So we definitely respect them. So we want clarity, and then after that, we can respond after factoring in everything that was said in this meeting. Thank you very much, Chairperson.
Thank you.
Chair, I think let us have a way forward now.
Yeah.
The way forward is that the committee, which is under your wing as the chairperson of this committee, you must plan this thing very, 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 very good. Because it seems as if your planning is also questionable, Chair. The reason why I'm saying so, the agenda that is in front of us, it stipulates very clear that we are going to have 2 ministers. And I must also repeat myself to say, even that what happened last week, your communication from your office says that the DG is coming, but only to find out during the morning when we are here. So please plan this thing accordingly, and then tell us that the minister, 2 ministers, when they are coming. We don't want to find ourselves to come in the committee and only to be told in the morning that those 2 people are not coming. So plan this thing accordingly, Chair, and then just call the committee to say, definitely sure, these 2 ministers will be available. Because I just want to dispute this thing that we must accept that these 2 ministers have went overseas. You just don't wake up today and go to overseas. Definitely you don't. You plan your trip to overseas. You prioritize your things to overseas. So meaning that, Chair, if those people were not going to be available today, I mean, your office should know that don't put on the agenda because they are not going to come before the committee. But only to be told on the last minute, I think as the committee we are being undermined.
Thank you. Honorable Steenhuisen, and then Melder will be the last. Oh, there is Mamkom, you'll be the last. And then I'm going to close this discussion.
Thank you, Chairperson. Chairperson, I just want to place on the record that, I didn't come here with some fantasy that the ministers were going to be here today. It wasn't something I made up when I got up this morning and thought, well, it'd be nice if I can dream that the ministers are going to be here. This was published on the Z list of Parliament on Monday, that it would be a briefing by the Minister of Finance and the Minister of Home Affairs on the naturalisation subject. I didn't make it up. It's not something I made up. It was on your agenda as well. So I do take issue with the fact that when I've come here with an expectation based on a Z list, an agenda, that the ministers are going to be here, that I'm somehow disrespectful for the fact that they're not here. I would venture to say, sir, that the disrespect is on the behalf of the executive, who are accountable to us, not the other way around. And I have a great deal of respect for the right honourable gentleman from KwaZulu-Natal, Mr. Gumede, and I have a great deal of respect for him. But with respect, the Constitution in Chapter 4 and 5 doesn't mention the word respect once. It says accountability. It says oversight. And that's our role. And so if we are going to operate in a mutually respectful way, it means that ministers have to be here. But Chairperson, I want to say to you that I'm happy for us to proceed as a way forward. I'm not trying to disrupt your program. But I can tell you at the end of the day, you're going to be very happy with the input from Mr. Apleni and his department, because my reading of the papers is that the systems worked. And they did what they should have done. And that's not where the problem lies. The problem lies with the exercise of ministerial discretion. And these gentlemen and ladies here today are not responsible for the exercise of ministerial discretion. And so that is the problem. So we can proceed today, but at the end of it, we're going to end up with that situation. And I would suggest to you, sir, that what we're seeing here is a diffusion of this very important issue. So the ministers are not going to come on the same day as the department, and when we try and question them around issues and try and see where the anomalies lie, it's going to be very, very difficult. And that's why, with respect to, I argued for the creation of a single ad hoc, and why these committee-type probes I don't think are going to be as successful. But nonetheless, as a way forward, I'm happy to listen to Mr. Apleni and his department, and I've got some questions for them, but I would venture to say that we're going to end up at the end point this afternoon that the problem does not lie with the department. The problem lies with the exercise of executive oversight, and that's what this committee should be applying its mind to.
Honourable Mulder.
Yes, thank you, Chairperson. I agree with my colleague. I've listened to what the colleagues have said, especially Mr. Gumede. He was doing very well. He said how we should respect the judiciary and how we should respect the executive. And then I expected him to say the next sentence should be, and how they should respect the legislature. But he didn't get to that point.
Speaking as a legislator.
The point is, Chairperson, political parties who do not respect the electorate gets into trouble. And that is our job. We should respect the the electorate out there, and we should respect the Constitution. We're supposed to do oversight. I also listened to what Mr. Gumede said very clearly. And my concern is not what he said, but what he did not say. I don't want us to get into a position that we listen to the officials today and that the officials give us all the details, and then we say, because the information we've now received, it's no longer necessary to call the executive. That's my concern. It's not for the officials to do the bidding on behalf of the executive. We must once and for all get that settled, that the executive should come to account to the committees of Parliament. So we can proceed, Chairperson, but I maintain the agreement that we reached last week was that those ministers should come and account. And the sooner we do that, if we're going to invite, we may invite. It's a question of priorities. And it's not all the ministers that are abroad, one is abroad. And even in the reply we received, in the apology, it says she's standing in for another minister. Fine, it's a question of priorities. Do I stand in for that minister or do I come and account to the committee? But all I'm saying, Chairperson, is let's proceed, that's fine. But it should not end where we come to a conclusion or the majority party comes to a conclusion it's no longer necessary for the executive to come and account.
Mango.
Thank you very much, Chairperson. I think this matter, following last week's meeting, and noting that the DG could not make it last week, is something which we do take note of because he had to be at the NCOP. We're grateful that the DG is here today, and we're hoping that he will give us the input. But I must agree with my colleagues when it comes to the final people or the main people that need to give us an input, and that is the ministers. We need those ministers here. They need to be summoned. I think, Chairperson, I'm not sure whether the letter which was written last week by your office was an invitation or a summon. Because if it was a summon, I think it would have been treated differently. So, Chairperson, let's move towards a summon and let's put a date and a time, because members are here and members will still be here. The investigation has got to take place and we need to ensure that everything is done properly. So, Chairperson, through you, let your office also play the role it should be doing to actually summon the ministers. If it comes to a push, go through the office of Mr. Frolik and all our senior politicians here, if they are not willing to come, so that at least they are actually expected to make an appearance. And it would be surprising if they don't make an appearance, because it's there in the Constitution, it's there everywhere else. So one is actually shocked at how things are going. Thanks, Chairperson.
I'm closing there. I'm closing there. I'm closing now, honorable members. I think, honorable members, last week, we made an arrangement that the DG should come. We never invited any minister to come last week. You see. And this is the first time that we have actually asked for the ministers to come. But then we are talking to this matter as if we invited them last week, they did not come. That means they are refusing. Even today, they are refusing. I don't think it is correct. We've made it very clear that last week we invited the DG. And yourselves, honorable members, you said you want documentation. To an extent that one of you ended up saying that it needs even the emails. And I had to intervene and say, you can't talk about the emails from the department. The emails are with those that have it. And they are the only people that can assist us with the emails. Because we want the department even to verify that, to say to us that those things are correct documents. They relate to what the department has. Up to now, we don't have points of dispute. We don't. Even last week, I think I said so. We don't have points of dispute. But we must understand that from the DA is that, like as I said last week, honorable members, that the DA has asked a question on this specific matter, and they've received answers on this specific matter. They've received answers exactly on the same matter. Hence, that's why the DA may be having another intention to complete which they are far ahead of the rest of us. We want information, want the department to tell us the process, and then what they've done, anything that's wrong or anything that's not wrong. We are still at that stage to be on par with what the DA knows. Probably Mulder knows as well, because it looks like they are in agreement with Honorable Steenhuisen on their intent on this particular meeting. But they must understand that we are not all at that stage. We wanted to get to that stage. The department must clarify us, might give information. I think that was the intention last week, which was not done, and honorable members wanted and even listed the information that is wanted. And the DG then has even gone to give us a report, instead of just giving us the documents and whatever that have gone through the department. And now, we talk about the agenda. The agenda is the one that makes us to say to you, this particular minister has apologized, this one has apologized. If we have just simply written on the agenda item that is briefing by the Director General, then there will be no need to tell you of any apology of anybody, because in any way you don't expect them. The agenda has been written in terms of the way we have agreed last week, because this is what is going to happen. But then now there are documents that explains the absence of those that are supposed to be here. On the side of this planning that Honorable Mkhalipi is talking about, it is not confusion. It's not confusion. It was an intent of this particular meeting, but then we have got these specific incidences that the members that we invited then are not here. But this meeting, honorable members, as you know, we have communicated from Honorable Frolic, it cannot be the first and the last meeting. It can't be. Then we should not take the posture as if today is a do or die meeting. We should not take that posture. Hence, then, honorable members, as you all agree, I'm not forcing you, you all agree, let's have the DG do the work that it's supposed to do, make all of us to be on the same par in terms of knowledge of this matter. Let's get clarities wherever you think that you are not understanding properly, because even the people out there at home, they are not having the same information that we have, because, like as I'm saying, is that the DA has got answers for this question, but it was written answer to them. Now, all of us and the rest of the public are not having the same knowledge as we're speaking. For them to be able to know that we are doing the right thing or we are not doing the right thing. Let us allow the department to take us to the same level, together with anybody that is actually asking us left and right on the street. Let the DG take us to that level. And then we will then deal with all these other political issues that are not administrative and not whatever. We must have points that are of dispute, that need somebody to come and clarify. And then we'll have a meeting, then we'll call those people then to come and sort that matter up. On that score, honorable members, I would like to really welcome the DG and the delegation, and then to proceed with briefing us. And I hope that members will listen carefully so that we are able to process the issues that we have. It's just unfortunate, those that are already having pre-information, then will just bear with some of us that are a little bit behind. so that then we know equally. DG, proceed. The people are waiting to listen.
Yes,
Amandla.
Honorable Chair and the honorable members. Chair, I think let me put it on record that I do respect authority, including the parliament. Two, I respect the citizens of this country and anyone who is within the shores of this country. Lastly, I respect myself. That's why I will never do something which will harm my integrity. Having said that, Chair, I think the approach, as we are saying that let's make sure that people understand this whole issue. I think it will be important for us before we get into the names that let's deal with the legislation. What are the provisions of the legislation? Because if we don't understand that, we're going to be talking out of 10. But once now we say this is the legislation framework, this is what has happened, and then we can match the two. And then if there's something which has not been done according to that, then that's what we'll deal with it. So, Chair, as a request of the committee, we submitted the report on the 22nd of June, which was last week, Thursday, to make sure that the members have got the report and we attach everything on there. So I will hope, as I've been hearing, that the members have got the report. And Chair, I'm really pleased that you said let's take the report into detail, not assume that people have read, so that I can be able to explain each and every step. So, Chair, the scope of the report is really to deal with the naturalization of the members of the Gupta family following their request for exemption to the ordinary residence requirements as stipulated on Section 59A of the Citizenship Act. And who are these members? It is Mr. A.J. Gupta, Mrs. Shivan Gupta, who is the wife, and Mrs. Anguri Gupta, who is the mother, and Mr. Kamal Singal, who is the son, and Mr. Surya Singala, who is the son. Then in terms of the immigration, those people must understand that we don't just come into a naturalization. You first come into the country as a foreign national. So in terms of that, Immigration Act deals with the admissions, how you sojourn in the country, and the departure of the foreign nationals. So foreign nationals who wish to come to the Republic of South Africa must apply for a visa, which then was called a temporary resident permit in their countries of origin, because they're not born here. And then these may be visitors, may be a study, a medical, a business, a work, a relative, or spousal. The visa, by its definition, is for a short-term period up to 3 months. It can be 5 days, it can be 2 days, it can be 3 months, it can be long up to 5 years. But now when we're changing the rules, we give even a 10-year multiple entry visa. But doesn't mean you stay here for 10 years. But you said 10 multiple entry visa, we've got 90 days per year, so that don't go and apply every time. Then a person requires a visa to legally sojourn in the Republic, and the visa now may be extended whilst you are here. Then now the next step, a foreign national who has been in the Republic on a visa for a period of 5 years qualifies to apply. Doesn't say we approve, but you qualify to apply for a permanent residence permit. And that second permit, again, you are applying it within the immigration services. Then a permanent resident permit holder has all the rights of a South African citizen, Chair, except one right, the right to vote. I think that is important. That if you are a PR holder, you've got all the rights of a South African citizen, except one right to vote. Okay? Then the application and adjudication of temporal visas and permits is managed within the immigration branch, as I've said. Then the granting of temporal visas permits requires foreign nationals to meet the criteria set out per visa type. However, in the event an applicant cannot meet any of the requirements, he or she can apply for a waiver. The laws which have been approved by this parliament has given that provision. It's not somebody just take it from the head or how you wish to do it. It's in terms of the law, which may be approved by minister in terms of Section 31(2)(c) of the Immigration Act. We make an example here. That the Immigration Act says if you want to open a business, you must have an investment of 5 million rand. But a person can make a presentation and says, look, that's what I have, is a 2 million rand. Based on that, the minister will look at it based on the reasons and then grant that waiver. Now, if the applicant is not happy with the outcome, within the immigration, I'm not yet with this civic issue, there is an internal remedy which is an appeal. This is a democratic state. You don't have an absolute power here. If I'm not happy with what we have done, I will appeal. I think that point is important. In addition, in our constitution, if the applicant is not satisfied with the outcome of the appeal, the applicant may resort to the judicial review. So it's not only the internal processes. You can even go for a judicial review because it's a democratic state. I am dealing with an administrative function. So in terms of PAJA, the decision which I've taken can be tested and be checked whether is it legal, is it, and all those kind of things. So that's what it is important about at this point. Then again now, once granted a permanent resident permit, an applicant is issued with a South African ID book. The only differentiation, it says non-citizen. But we've got an ID book. And once we have it, it means it follows. You can have a passport, you can everything. But as I said, the only right you then have is the right to vote. So that is immigration services. Now we come now to the civics. Now when we can naturalize, because you can only be a citizen if it is by birth, or one of your parents, whether it's a mother or a father is a South African, will be a citizen, or by naturalization. Now, for you now you graduate actually, because it's just a number of years. Now it says now, a foreign national now who has a permanent resident permit and has completed 5 years in South Africa, now is the second point now, qualifies to apply for naturalization. And I can't deny you, whoever you are, once you finish that 5 years, you qualify to apply. I don't have a discretion at that point. And if I don't do that, you'll be taking me to court. And in terms of the act, I will be acting irrational. In terms of Citizenship Act 1995 as amended, let's go now to this section. But Chair, I said let me copy the act, so that is not what I am saying. It's Annexure A of the act. I'll go to that Annexure A. It says now, the minister may, upon application, in a prescribed manner. Once the act says prescribed manner, it means now we'll have regulations to manage that. It's not in the act everything, because it is in a prescribed manner, which those regulations themselves are presented to Parliament and they approve them. Then it says now, a citizen who satisfies the minister that he or she is not a minor. So when I'm dealing with these issues, I want you now to be able to say to me, this individual is a minor, therefore we have done something wrong. But if they don't, then there's nothing wrong we've done. He or she has been admitted to the Republic for permanent residence. So you can't apply for a naturalization if we have not yet been admitted as a permanent residence holder. You can't. But we'll come to it when now there is this discretion. He or she is ordinary resident in the Republic, and that he or she has been so resident for a continuous period of not less than 5 years, immediately preceding the date of his or her application. Let me explain this, what this thing means. You might be a permanent resident holder for 10 years or 15 years. You may be, but you didn't ever wanted to apply. But now, before you apply again for naturalization, you must be in the country for 5 years. But what the regulation looks at it anticipated that a person can't divorce completely with his or her country of origin. Then it anticipated that let's have a provision to say, within that 5 years, you can be allowed to go to your country of origin at least 90 days per annum. That is very important, because if we don't pick that point, we're going to have an issue when we deal with other issues. You must be in South Africa for 5 years preceding your date of application for naturalization. However, the legislators, which is not us, Parliament, anticipated that people might not be completely divorced with their countries of origin, because in other countries they allow dual citizenship. There's nothing it says, once I take citizenship of South Africa, I'm no longer a citizen of my country, I can. So it anticipated now that people will visit their families, but in that you must have 90 days in each and every year, which you are allowed to do so. Okay, he is ordinary. Then it says, now, he or she is of good character. Chair, how do you measure that? This is a democratic country with people with constitutional rights. I can't look at your face and simply says, hey, you are not a good character. What do we use? Is that we go and check whether do you have any criminal record. That's the only measure which I can use and say, I check whether I've got a criminal record, if you've got in your police, in your country of origin, if you are clean there, I am not there to judge you based on what. So that's what that point again now means. So that when we come to it, to say, did we check those things in the process for anyone? Because remember now, I'm not there dealing with the people, I'm dealing with the rules. He or he intends to reside in the Republic or to continue, that's fine. He or she is able to communicate in one of the official languages of the country. We've got 11 official languages here. So if you can pick one of those, it's fine. He or he has adequate knowledge of responsibilities and privileges of South African Citizenship Act. Chair, what we have introduced in this regard now, starting in 2016, because these things, they evolve. We have now introduced that people, when on the day that they are naturalized, a judge goes and manages that process to say, allu allegiance to the constitution of this country. We started it in 2016 so that we make sure that people understand what this thing means. He or she is a citizen of a country. That is important, Ghana. He or she is a citizen of a country that allows dual citizenship, provided that in the case where dual citizenship is not allowed by his or her country, such person renounces citizenship of that country and furnishes the minister with a proof of such renunciation. But I think what's going to be important here is the sequencing now of what this thing means. Because if you don't understand that, you're going to misinterpret it. Before I get to it, let me make an example so that when I explain it, you can understand. I am a DG of Home Affairs now. Then a post is advertised for a CEO of company A. I'm still a DG of Home Affairs. I won't even tell my principal as I'm applying because I don't know whether I will get a job or not. And then I apply. Then I go through a process there of application. Then they tell me, but hey man, we have been successful on an interview. But what we do here, we test medical, we test security. Then for me, because I think I've already got the job, I go and resign in my job in Home Affairs in anticipation that I will get a job. But I don't meet the requirements on that side, whether it's medical or security clearance. What will happen to me? I've lost the job of Home Affairs. Don't have the job where I'm going. Then I will be jobless. Let me explain again now this. If now you apply, you are from a dual citizenship country, you can't go and renounce your citizenship before yours has been approved, because you will be stateless. You go and renounce your citizenship on country A, you are in anticipation that this one is going to be approved. Then on these things, there is something you don't meet. And then you are no longer this country and all the other. And Chair, we know what happened here in South Africa of a player. A player who, because of the requirement that before he can go and play, I think was Netherlands, he had to have certain caps on Bafana. But because he couldn't get it, then he went and take the citizenship of Netherlands. He lost ours. And then now when that player to play for Bafana, he had to come and appeal and say, I can't play Bafana because I'm no longer a South African. What did we do? We left that person and left them on the wolves? We didn't, because people don't understand these things. So you can't lose your citizenship, Chair, before the other one is confirmed. You will be stateless. So I wanted to explain again now that principle in terms of the sequencing. Because if we don't understand that, when we deal with these issues, there are questions to say, when do you re-announce or whatever. But I wanted you to understand about why you have to do in a particular sequence. Furthermore, if the applicants for naturalization have children or dependents, and they explain who those dependents are, it can be a mother or a father. They must apply as a family, but is a choice. So can I emphasize that? It's a choice that I decide that I will apply for this naturalization as a family, or I can apply as an individual. But if you apply as an individual, you'll be evaluated as an individual. If you apply as a family, we will evaluate you as a family. But you remember the criteria is the same, whether you are a family or you are an individual. Then again, the important point it says, it should be noted that if one of the family members in the group does not qualify, then the whole application is unsuccessful. I think that point is very important, so that when we deal with the individual, you understand that you can apply as a family, but if you apply as a family, all of you must meet the requirement. If you apply as an individual, you must meet the requirement. So if one of you meets the requirement, but as a family you don't, then that whole application is not. Then again, now the Act says, in the event that an applicant does not meet fully the prescribed requirements set out in B, what means again now is that, which I will go to the Act, that person should ordinarily be resident in the Republic for a continuous period of not less than 5 years immediately preceding the date of his or her application. He or she may request the minister to consider to waive the requirement based on exceptional circumstances in terms of this Act. Let's go check to Annex B so that we read it from the law. Annex B, we wrote them B, triple B. If you go to triple B 9, It says, notwithstanding anything to the contrary contained in subsection 1C, the minister may, under exceptional circumstances, grant a certificate of naturalization as South African citizen to a publicant who does not comply with the requirements of section 1C. So, Chair, it's not everything. Let's go now to 1C on that annexure, which I read it, annexure A. 1C, where the minister has got a discretion, does not have a discretion on all. It's only on the one which says that he or she is ordinarily resident in the Republic and that he or she has been so resident for a continuous period of not less than 5 years immediately preceding the date of his or her application. So that's only where the minister will have a discretion, is when that person has not met the requirements of being a resident in the country for 5 years, whether it's 90 days or whatever. That's where the discretion can be exercised. So, Chair, let's move. Then, Chair, now let's come now, how do we process the applications? And I'm not sure, Chair, I will get your guidance whether at this point, maybe you want us to get questions at the end, or maybe at this point we can ask, is there anything which is not clear in terms of the law? So that now, because I want us that by the time we get into the names, we're able now to say, okay, I understand the law, or there was a clarity. But under your guidance, Chair, if you believe that, let's proceed, I'm fine.
Honorable members, there is a plea. Do we take the plea or do we ask him to continue? Because Honorable Gumede.
Thank you very much, Honorable Chairperson. Whilst perhaps I understand that perhaps we want to continue, I think it would be important to clearly understand the law before we have names, because names are going to bring bias into this matter. It's better to discuss it before we are exposed to bias. Thank you.
Can I just be corrected? Do I hear you saying that we must open the law to be for points of clarities, or we proceed with the processing?
I request that we have all clarity we need, so that when we come to names, and then there comes a name I do not like, Gumede, then we have clarified ourselves about the law. Thank you.
Okay. I have seen Honorable Steenhuisen was saying, let's proceed, let's run. But let's allow those honorable members that would like any clarity in relation to the law that has been spelled out to us now. And then when that is done, and then say we'll now go to the processing from point 13. Mekenye, then Medambuza, then Meraputi, then Honorable Steenhuisen then will come in that order.
Thank you, Chairperson. Thank you, DG, for the explanation, but I think just clarity on the issue said that you can't divorce a person from this country of origin. And you further said that some have got, some don't want, some countries doesn't recognize dual citizenship. Now, in the case of a person now who supposed to, I can understand that in some countries there is this that says that you can't get, there's no objections of the person coming to this country, provided they have surrendered the citizenship of that country. In that case, what does the law say? Thank you, Chairperson.
I hope that the DG and the big delegation are taking notes. And,
sorry to add, just
yeah,
to expand.
Add.
Because that person is supposed to sign the Declaration of Citizenship Allegiance so that the application is finalized. Thank you, Chairperson.
Yes, and then Honorable Dambuza.
Chairperson, I just wanted
Can I ask Honorable Kenya just to switch off the mic? Thank you very much.
I wanted to say, Chair, to comment on the interpretation
of the law
by the DG. I might differ from his interpretation on this clause, which is clause H, because he makes an example of a person who applies and so on in the case of a job. But here, it's clear that you need to provide a proof before. This, according to me, OH is saying if he or she is a citizen of a country that allows dual citizenship, provided that in the case where dual citizenship is not allowed by his or her country, such person renounces citizenship of that country and furnishes the minister with proof of such renunciation. I wanted to put, I differ with his interpretation on this matter. Thank you, Chair.
Meraput.
Yeah, thank you very much, DG. When you were explaining, you said that the person after being approved, or the person on the day of naturalization, the judge must be the one who endorsed, and it was introduced in 2016. So I just really wanted to check how it should be done. That how should the judge endorse this naturalization, and where? How and where? I thank you.
Honorable Kakana.
Thank you, Chair. My point exactly was what Honorable Dambuza raised. Is where I differed with the DG. But also, before we get clarity from the DG, I think the legal department is here. So they must also assist us in defining or interpreting all these things before we will go to the next chapter of the Guptas. Thank you.
All right. Honorable Steenhuisen had a hand up. Yes, it's your chance.
Thank you, Chairperson, and thank you, Mr. Plenny, for taking us through those regulations so succinctly and clearly. I just would like to deal with the Chapter 5, or Section 5(9), which you read from, if I may, 9A and B. May I ask you, sir, what discretion you have granted in terms of that legislation to make a determination there, whether that the Act passes on any discretion to you in terms of Section 5(9)(a) and B, and who is responsible for then in terms of 9B? Is it you, sir, or the Minister is responsible for ensuring that it's tabled in the National Assembly in terms of meeting that requirement? Then in terms of your explanation around dual citizenship, thank you very much for that. I would just like to understand, what would you regard as proof of renunciation? And is there any mechanism that the department has to ensure that such renunciation has in fact been effected and that the person is not illegally a dual citizen of a country, having just supplied a single letter from a consulate to you? So I think what we're looking for is, what checks does the department have in place to ensure that that section has been complied with? And then in terms of, again, 9A, it refers to exceptional circumstances, sir. Now, we already know that in determining or making, exercising executive action, those exceptional circumstances would require to be rational and reasonable. Do you have a benchmark of what you would regard, as the department would regard, or the minister would regard, as what is exceptional circumstances? And is there a set of qualifications against which the department, or the minister in this case, would exercise determination of what qualifies as an exceptional circumstance? Thank you, Chair.
Thank you. Any other one? Thank you very much. Honourable Melder.
Thank you, Chairperson. Thank you to Mr. Penny for the answers and the elucidation so far. If I understand correctly, when you start with the process, you have a choice, either as an individual or as a group or a family. And then everybody has to comply in terms of that group, as was the case in this instance. Is that the case throughout the process until the end? What I mean is, can it change in between, in the middle of the process? Can it suddenly then be changed that now we no longer deal with a group, we now deal with individual cases? Or does this have to be right through to the end? Thank you.
Okay. No, thank you very much. I need to applaud you, honourable members, that now you have got into a gear that you are empowering the citizens of this country. The questions that have been raised for clarity, I think, will empower everybody. The DG.
Thanks, honourable members, for the questions. Now let me start with this that says we cannot divorce you from your country. I was explaining it on the basis that if your country allows for dual citizenship, I cannot divorce you. But where it is not, you are divorced because you make a choice that I'm no longer want to be a citizen of that particular country. I want to be a citizen of this country. So it is in that respect. Two, surrender this, which now going to come to this issue now for dual. That's why, which is come to your question as well. Remember what I was talking about here is the sequencing. At the point that we must issue you with a naturalization certificate, you must have renounced, but not in the beginning of the process. Can I repeat what I'm saying? You remember, you start apply to us, you submit a form to us to apply. I am not expecting you that at that point you come to me and say, one of my attachments in the application is a renouncement certificate of your country. You can't. Because at that point is what I'm saying now, you'll be stateless. But I can't issue now finally with a naturalized certificate before you give me a proof of renunciation. So I was explaining, so it's the sequence. It's not that I'm saying we can finalize your naturalization, give you a certificate, and thereafter you come back. No, it is but I will show you when we deal with the actual case, but I wanted to explain it. It's a process. At the time that I apply, I make sure that I've got a permanent residence, I've got whatever, and all that, and all I submit. Then you consider. But on the day now, before I issue you with the certificate, that now you've got a certificate, you've got a new ID number and all that, you must have given me that proof that you have renounced. So that's what I'm explaining. Then the allegiance and all that, though, are in the steps. That now you issue now the allegiance certificate and all, you do that in the steps. So this thing has got steps. You apply, you do this, you do this, you do that. Then now, I've already explained now that at what point do you, Honorable Tam. Then, Honorable Raput, no, as I was saying to you, we started this thing in 2016. We had two of those naturalization ceremony, and we're honored that they were carried by the Judge President of Gauteng, Judge Mlambo. Yes. So what we do, after we've done all those things again, as I'm saying, is a step. on the day now that they must be given those certificates, the judge reads them a point to say, I understand this and this and this, and then I allege to this, and then we sign the certificate, and then they agree. So it's the oath of allegiance. So we do it like, but we started it in the 2016. Those who were naturalized before did not get that. Then the Honorable Kegana did respond to this and say, but the legal people can still tell us that what I'm saying, is it correct or not? I don't have a problem with that. Then now coming to Honorable Oosthuizen. You are right. When you ask the question, who has got a discretion for that? It's the minister. Who has got a discretion for that? But I will explain. We're in a bureaucracy here. No minister who sits in a corner there and just do this. Officials prepare documents to a minister. And we recommend. A minister can either approve or disapprove based on what we have done. But I will explain when we deal with it, but the discretion lies with the minister, and then even if it lies to the minister, a minister can decide. There is this thing called delegation of powers. There are powers which are with the accounting officer in terms of the Public Finance Management Act, but I've got only 2 hands. I can't be everywhere in the department. But when I've done that, we have delegated in writing. So get these powers, these ones, were not delegated. They're still with the minister, okay? And then proof of, what is the rationale? Well, this can be a subjective matter because to you, this thing might sit as if it is not a matter. But to me, it can be a matter. But is what can be tested in terms of rationality. That's why and again, are you applying this thing consistently? It's another test that if I've done this to you, I will do to this and I will do to that one. Then if I'm not doing it like that, then it will fail the test of rationality and consistency. So, but when we deal with the reason, we will be able, that's why even in our file, for another reason, we've put names there. When we deal with that, to say who else in South Africa has been naturalized. We'll read them the names, some you know them. And then now to say, this was the reason, this one was that. That's why that section 59B says, give the reasons. Why did you do this? But yeah, we'll deal with it when we get there. And then what are the checks and balances? Well, you know, as a department, in everything, it's like now said, yes, we will check, but what you submit to us, we have submitted to it. If we have done something wrong, we must deal with you in that scope. But as what I checked is that, is this thing authentic? Has this thing been issued by the country which it comes from? If I've proven that, what else must I do beyond that? And then if you have lied to us, then we will deal with that issue as people are lying on all these things. So there is a process which we follow, and then we will look at it. Chair, let me proceed. This was the last question. No, sorry. Honorable Mund says now, can you change? Yes, that is a very important question. You see, is that I'm saying that if I've applied as a family, I will be that family. If I don't qualify as a family. But the point which is going to come here is to say, but if for me we have approved now, because that's how I was saying now, that thing is a condition. We have approved everything. And then you come to me and say, denounce your citizenship. And then I say, no. I can't say now because me, I don't want to denounce my citizenship. Other people, when I cannot take the citizenship. But we'll come to that. You'll see when we deal with it. Okay. Let's go now to...
Let me just check DG. Honorable Kekana, do you still want the legal people to vent on this particular matter you raised?
Please.
Okay.
Let them do that.
Okay. Honorable Steenhuisen?
Sorry, just the one question that, forgive me if I missed the answer. It It was in terms of the responsibility in terms of 9AB.
Yes,
Who,
the tabling.
who is responsible in terms of the legislation for tabling the list in Parliament? Who does the legislation hold accountable if that process is not completed or done or complied with?
Yeah, okay. Just respond.
Yes, no, I said the person, in terms of the act, it says minister. We can go and read both. Go and read 5.9 on that BBB. It says, notwithstanding anything to the contrary contained in subsection 1C, the minister may. I said that has not been delegated. Then 5.9b, it says, the minister shall, within 14 days after the commencement of the sitting of Parliament in each year, table in Parliament the names. That's what it says. Yes. Come again. No, it's not delegated.
Sorry, Chair, through you. I just wanted to confirm that that power had not been delegated.
It has not been delegated.
Thank you.
Yes, I think that's what has happened, and I just remember one point that you have said, DG. I think it needs to be clarified because you talked about some bureaucracy. Yes, Honorable Mnisi, I thought I heard you properly. Yes.
Thank you very much, Chairperson. I just need clarity from the DG on the question of applying as a group and applying as an individual. I just want to check, Chairperson, can family members come for the second time? If they fail as a group, are they allowed to come back as individuals, no longer as a group? If their applications was not successful as a group, then they come back as individual.
Exactly.
Okay.
Exactly. Because I come as a group, I decide now I want to come alone. And you remember, these people are talking about here are adults. In South Africa, once now you are an adult, then you can contract and you can do whatever we wanted to do, as long as I've explained that that A said you must be 18 years and above. Okay? But we'll explain when we deal now with that. But it's a good question. So that when we get into the names, then these issues now going to be coming up.
Okay. Let me just check with the lawyers there, as one member still wants this matter to be clarified. Is there anything to be said in terms of the sequence? I think it was on the sequence, the renunciation, and the issue of the certificate of naturalization, and then the sequence. I think that's where you wanted legal input. Yes.
Thank you, Chair, and good morning to the members of the committee. I'm Advocate Gordon from Parliament's Legal Services. Chairperson, my colleague and I have looked at this provision of the Citizens Act, Section 5.1, and the subsections that relate to naturalisation. And we are in agreement with the interpretation given this morning by the Director General of Home Affairs. We particularly draw on the fact that the application is subject to the prescribed manner set, and also that the H part, which relates to the sequence of application, provided that in the case where dual citizenship is not allowed, that an applicant renounces citizenship of the country where it's not allowed. We are also aware that the manner in which this is applied is consistent with the interpretation given by the Director General, that it is a suspensive condition, meaning that South Africa would offer an applicant a successful answer to an application for naturalization subject to renouncing citizenship with another country. So it doesn't happen before, it does happen after. So we are in agreement with the interpretation by the Director General. Thank you.
Okay, it looks like Honorable Kekana is happy about that explanation. Honorable Sope?
Yes, Chair, just the clarity on the explanation, on the renunciation of citizenship. So when exactly? Before you apply, you must announce, as the DG was making an example of applying from other departments as the DG, or after we've been granted. So can we just get a clarity when this issue comes in?
It's just a little bit difficult. It is now the DG that must answer that one. It's the DG. Yes, the DG
No, it's
proceed.
simple. That's why I was saying this thing. As long as you understand the process, that's why I was making an example like a job. When you apply for a job, that thing has got a process. You apply, submit a form today, you get a short list, you go to an interview, you go to all those steps, and then lastly, when now we are giving you a letter of appointment, it's because we have satisfied all the conditions. Let me come to this one. You apply to say I finish my 5 years. Your first requirement, I must have my 5 years permanent residence, and whatever you submit, then that thing is looked at it. After he has looked at it, I'm going to explain now when I come to the processing of civics. There is a panel which looks at that. Then after that thing of yours has been approved, then now if you are from a country which needs a dual citizenship, they write a letter to you and say, now we've considered your application has been approved on condition that you submit this. Then before we go to the system now and capture you as a South African, all those conditions must be met. Then now we have submitted your renunciation, then I can issue now with the ID number of South Africa. Thanks, Chair.
Do you still need the lawyers to speak to it, or it's clear? Thank you very much. Yes. Now we are being empowered. The DG proceed.
Let's come now to what is the process now of how to deal with these things? Because there is a process which we set so that we make sure that everything goes through that. The first thing which we do is that it is important to know that the initial processing of assessment, that's why I'm saying, Chair, on that bureaucracy we're talking about, does not sit in a minister in a corner and just approve these things. It is important to know that the initial process of assessment involves preparation of a submission by an official. There is an official who must get this thing, which when I deal with it, I will show what this is the submission which they prepare themselves to look at what is the criteria, what is this. Who goes through the file and collates all information in the submission to be presented to the Naturalization Adjudication Committee. Chair, why did we have a committee? Not a one-man or lady person sit and just make a decision. You need a panel so that you make sure that this thing is looked by a committee, not by an individual. Because granting someone a citizenship is not a child's play. Then that committee is chaired now by the chief director, who's next to me now, and then if he's not there, somebody else chairs it, and then it's got 3 members. The committee, now, what is the role of the committee, Chair? Which when we deal now with that issue, which we're going to come to it, the letter, my minister, and overruling somebody else. The committee ensures that the applicant complies with all the requirements in terms of its role. Committee either approves or rejects. So it means the approval of that is with the committee, is delegated to the committee. It's not delegated to the minister, it's with the committee. And it can reject the same committee. So it means if your application is successful at a committee level, it gets implemented. If it is not, it gets rejected. The committee has got the power to reject. Then we're going to come to say now, what are the provision of 5B now? But I'm just bringing the explanation. An applicant will now submit, an applicant will submit an application as an individual, as what I've already explained, even what form they do. And then now the Directorate Citizenship verifies the authenticity of the issued permanent resident. Is this certificate issued by the department or not? If the naturalization and education approve the process of issuance, the applicant must then, with that process, must then sign declaration of allegiance, where the applicant's country, do you see now where it comes, does not now allow dual citizenship. The applicant must submit the renewalization certificate letter from the country of origin. Is the process, that sequencing I was talking about. Submission of above stated document will lead to the changing of identity number from permanent resident identity number, which provides for all rights, including the right to vote. Failure to submit a signed declaration of allegiance or renunciation letter will lead to the naturalization certificate not being issued. So you can comply with all this, but if you don't meet the conditions, that certificate won't be issued. Okay. Chair, I think now I've explained the process within, what is the law, what is, let's come now to the individuals which were listed in the letter. So,
second, honorable members, are we happy about the process? It has been claimed, it has been explained clearly, just on a theoretical basis, without attaching names, just the process as outlined. Honorable Stienese?
If I could just get clarity from Mr. Apleni, if I may. So that committee that sits would be the committee that would consistently sit on these types of matters. It's a permanent committee. And they would then be able to adjudicate their decisions based on previous decisions that they've made in similar circumstances. So it would, I would imagine, remove the arbitrariness out of the situation, because the people sitting on that committee would have had the experience of rejecting applications before and approving applications before. So that is the check and guard for consistency in your department. Is that correct?
Exactly, that's what we do. So that we make sure that that committee is appointed. We don't appoint a committee for a particular application and then appoint another committee for another application. That committee is appointed to deal with these things, and they're able now to maintain those issues of consistency and the application of the law. Okay. Then, Chair, let's go again now to the individuals now. So I give now chronological step followed by the applicants on each one. What did we do and all that? Let's start now. Mrs. Anguri Gupta. The applicant applied for and was granted a visa, then called temporal resident, dated 28 December 1995. It means this person arrived in this country just 1 year after the dawn of democracy in this country. So was here in 1995 with a temporal residence permit. So that when we deal with this fast tracking and all that, we understand it, that this person arrived in this country in 1995. And then again was issued with another one in 1997. That's why I said this means that she arrived in the country in 1995. Further, I applied for another one for reunion with the family in 2001. Then, according to our records, we have looked at it. She has been here for about 6 months' time during those periods. Then, Mrs. Gupta applied for a permanent residence permit, which was approved in 10th March 2003. Chair. Permanent residence. 8 years after her first TRP granted in 1995. So it means this person, as from 2003, had all the rights in South Africa except the right to vote. Is that clear, Chair? Okay. Then, thereafter, Mrs. Gupta applied for naturalization now on June 2013, I said as part of the family, which was 10 years since she was granted, we say temporal, since she was granted a permanent residence permit. as against a requirement of 5 years. So when Mrs. Gupta was applying for naturalization, if you can add all these years, I mean, the other one I said what was 8, other one was 8, and then the other one was 10. So it was 18 years, this person in this country. And Chair, I said when I was opening, I respect the citizens of this country. I respect people who are in these shores of this country, because I couldn't discriminate in 1995 and says, no, you cannot come here or for whatever. I don't have reasons to do so. Not unless there was information which says you are not a good character. Okay? Then let's read again now based on what you said. This committee, her application was rejected by the adjudication committee on 23rd December 2014. Let's go there again now, Chair. And next, C is that bureaucracy I was talking about to you. And you see now this thing is rejected by the committee. Now, here is a submission, is on C to CC. It says now, to obtain, it is a committee. Now, remember, in fact, Hlatshwayo is the one who signed this document. Hlatshwayo is the one who wrote that letter, which was in circulation. So she was a secretariat, is a female, is a miss. Yeah, she is a secretariat of this committee. Now, if they give background, her permanent resident was issued word, it was verified. Number 4, Chair, 2.4, the police report shows that there is no illicit activity identified. There is no adverse information on the applicant's police clearance certificate. Chair, what is important, Gena, is this thing below. Period of residence. Chair, it means, remember I said 5 years preceding. It means now this person on year 1, year 2, year 3, year 4, she did not go out of the country. You see, check the zeros. But now in the year 2013 to 14, she was out of the country 3 months and 18 days. So it means she exceeded the 90 days by 18 days. What made this person not to meet the requirement is because in the last year, in the last 5 years preceding her application, has got a 1 year where she was out 3 months and 18 days. That made her not to qualify. That's why, again, if you go to the next page, the committee did not approve this application. And the reason why they did not approve this application is because this person did not comply. They put what is the regulatory policy or regulatory compliance. If you go to bullet B, it says, as a regulatory requirement, any person who lodges an application should not have been absent from the Republic for a period of more than 90 days in any year during the 5-year period of ordinary residence immediately preceding the date of application of naturalization. In view of the fact that Mrs. Gupta does not comply with the requirements, refusal is recommended. It's the committee. Let's move. What did we do? Hlatshwayo, as a secretariat, writes a letter to the family. One of the things, if you go to paragraph 2 and paragraph 3, it explains to them clearly what made her not to qualify. It's because they don't meet that requirement. Then the last paragraph, which, Chair, I saw that letter which was circulating. That letter has been, what is the right word now? No, it's been tampered with. Yes, that letter said, however, you and your family will qualify to reapply on 23rd December 2017. That letter says 2015. It's wrong. It is 2017, and I will explain why it was 2017 and not 2015. So that's the first thing which is wrong in that letter, but we're not discussing it now, but I'm just highlighting it. Okay, then let's go to the next person now.
Yeah, shouldn't he just deal with the five names? And then because whatever you may raise, maybe it is also applicable to the other persons. Yeah. Let's just complete that bunch of the names of the 5 names, and then we will subject it for clarity.
Let's come now to the 2 applicants, again part of the family. AJ Kumta Gupta and Shivan Gupta. Shivan Gupta is the wife, and AJ is the husband, and AJ is the son. Come again? Annexure E. Annexure E. Okay, it's the same from there, but what is important is the period of residence, 2.61. If you look at 2.61, husband, Mr. A.J. Gupta has been in the country, did not exceed any period. In the 2013 to 24, it was 1 month, 18 days. In another year, it was 2 months to 5 days, 1 month, 2 months, 10 days. So in terms of that, he has not been out of the country to make him not to qualify. Had he applied as an individual, he would have got that without anything because he complied with the regulation. But he applied as part of the family. That's why it made him not to qualify.
Honorable Melder, I will still request that we hold on so that all the names then we have them. Just try and make note that we just go through the names and their circumstances in relation to this application. Then we subject it to your inquiry.
Then now on number 2.6, the wife. The wife did not have the 5 years. Was short of the 2 years in this. Then that's why our application requires applicants to apply as a family. If one of family does not qualify, it affects the rest of the family. That's why they were putting that there. And then now you come to the next thing. It says now, in view of the fact that does not comply, refusal is recommended. They write whatever the committee. Then now we go to the sons. The sons, Chair, because we were worried about that, this thing of a surname might be an issue, is Kamal Kant Shingala. So we said people are going to say, hey, these are not Guptas. That's why we attached the letter where in terms of the culture in India, a child they name it as Shingala, but it's the same thing as Gupta. So these are the sons, but they are following a surname. If you look at these ones, this one, they are, firstly, what is important, they are more than 18 years at the time of application. So the youngest, who is Surya, who was born in 1995. By the time now he was applying, he was already 18 years. So he was above the years. And if you look at them in those dates, they arrived in Nabapongo 1995. I think that one arrived here as a child, really. He arrived in 1995. So if you look at them, their period of absence was less than if you look at the schedule. And then, Chair, it means now they were qualifying. You will see now if you read, in view of the fact that Kingala, though it says does, it's supposed to say does comply with the requirements of section, the approval of his application is recommended to him. But because they were a group, then now all of them, they did not qualify. It's the same with the next son. They did not qualify. Now, Chair, once that now has happened, the committee has declined these applications. Now, what is the rights of these people, not them, anyone? Then that section 59A starts now to kick in to say, we have failed the application because we do not qualify with that 51C. Now, what can we do? It's within their right. It's in the law. Then now you can approach the minister with your exceptional circumstances. Then, before I get to what the letter, let me deal, Chair, with this thing, because when we get into it, the letter of Hlachwayo and the letter of the minister. Chair, this country, this one, has got a hierarchy of the courts. You go to a court A, which I've done in a lot of cases. I go to the Court of Appeal. You lose a case there. Then it goes to the Supreme Court of Appeal. It reverses the decision which was taken by the lower court, because it's the hierarchy of how things happen in our country. But what you cannot do is that now I'm at a lower court, I change the decision of the higher court. That's why they will call that as a contempt of court. You can't do that. So, Hlachwayo, letter they are writing is within their own right, is what they are delegated with. They've applied the law right, and they were able to say, these people as a family, they do not qualify. And whether one or one qualifies, but they dealt with that. Now, what happened now? Comes again now to this bureaucracy I was explaining. Go again now, Chair, to Annexure J. No, in fact, we can go to Annexure I. Annexure I, they exercise their right to say, in terms of that section, we believe that we are in exceptional circumstances, which can now, as we're discussing now with Honorable Oosthuizen, it will depend now whether now to you or to me or to anybody else are those reasons carry a weight. But on that thing which you were saying, I'm going to be giving you others who have dealt with it and check whether when I compare this and compare that, it means that there was something irrational here, which can, if that is the case. But I'm not going to read the letter because it was already there. It says now they've got investment in the country and all that. They've employed 7,000 employees. They've got whatever. They've invested about 25 million. But, Chair, let me correct something here, another assumption which can be made. There is an assumption which now says we must believe that the money which is invested by the Guptas can only come from AJ. Chair, I don't know. The family, the first person who came here is the mother. And I'll be wrong if I can think that if I am rich, my richness can only come from me as the son. I can inherit something from my mother. So why now we believe that if the letter is saying this is the investment which we have, it is equal to, that is the son who's got that money? Secondly, it's a wrong assumption again. If now I believe that my wife can only be poor, it can't bring anything to me. If now I applied with my wife on this, the person who's got the money here is me. It might not. So what I'm trying to explain here, Chair, in this thing is to say, that business is of that family. I don't sit and say, tell me about this one contributed 10%, this one contributed 5%, this one didn't contribute anything. That's why, Chair, in the letter we explain, where do I get that? We go to DTI, but I wasn't going to touch those things here. DTI confirms about this business is registered. We go to SARS. SARS confirms that this business is registered here, is paying tax. So what else must we do? But what I'm saying, let's correct this assumption that if now there is AJ, there is mother, there is a wife, the only person amongst the three who would have contributed here, it means it's AJ. It's an incorrect assumption. Let's continue, Chair. I'm talking about our bureaucracy now, coming to that question. Here, Annexure J, how do we do this? We said first, we start with the committee. Committee has done what they are doing. In a bureaucracy, Chair, no minister would just sit and write a letter. A minister is advised by his or her lieutenants, which in this case, the last one is the DG. If in the line we have applied the principle wrong, yes, the minister is taking the ultimate responsibility. But the steps below, they are also not clean. You can't say, no, I was passing it up. I've got a responsibility as each level that this thing is not complying, this thing is wrong, this thing is like this, and then based on that. However, the minister ultimately, he must look at it and say, I have satisfied myself, everything is okay, yet then I can do it. Let's go again now to this thing. It says now the purpose to submit for ministers' consideration. Annexure J. Or maybe let me be J by, I want to go to the J number, J by 5, 1, 2, 3, 4, 5, 6. If you can open that, but I want to start from the back. If you go to the J about 5, you know, the person who prepared this document is Mr. Skakana is here, is sitting here. No? Then from Mr. Skakana, it came to Mr. Ramashia, who is sitting here next to me. Then from there, it went to Mkiza, the DDG, who is not here today, but we know him. Then from there, it came to me. And then from there, it goes to the minister. So if now these people who are here on the line have not advised the minister properly as bureaucrats, they did not understand what these laws means, then is a problem. But I'm not saying the minister is the final approver. Must simply say I've been advised. But Chair, he does not sit in a corner and write a letter. What is important here, Chair? 6.2 on that last JJ, a draft reply to Mr. Gupta is enclosed for minister's signature, please. Should minister concur with the contents, therefore? So it says now that we are recommending minister must apply his mind, and then now based on that, look what that the law is complying with everything. So that's what as bureaucrats we did. But Chair, what is important with this submission, I want us to go now on the JJ. Yeah, J by 2. Yes. You see, if you go to 2.3, it says now the applications were adjudicated on 23rd December 2014 and were rejected due to the fact that Mrs. S. Gupta, wife, and Mrs. A. Gupta, mother, did not meet the residential requirements. It's not all of them. That's why we're explaining, Chair, to say the other 3 met the requirement. However, because as a family, did not meet the requirement. That's why we are mentioning it to the minister, so that he mustn't sit and say, all this group did not meet the requirement. But it's only two, but the motivation is for the whole family. That's why Getcha was coming to that issue to say, it mustn't say, no, because it's Mrs. Gupta and Mrs. A. Gupta, those letter of motivation can't fit to them because I've already judged them and say the one who brings richness to that family is this person and that person and not the other. Then Getcha, it goes and say, which I'm saying 2.4, it raises to say Mr. Gupta and the two children did qualify. Their application were rejected as per regulatory requirement under Section 3.4 of the Act, which stipulates that all members of the family, it says now, including the applicant, must qualify to be issued with a naturalization certificate. According to the calculation, they will qualify for naturalization on 23rd December 2017. It's the same with the letter which is written by Hlachwayo to the family and say, you will qualify in 2017. And then it goes again now subsequently to the refusal. We receive their motivation in terms of what business do they have, and we quoted. Then now number 2.7 is what is important. The document submitted from South African Revenue Services shows that Oak Bay Investment is registered with them, according to the information certificate. So, Chair, we verify those information. We don't just sit and get a letter and then thereafter we say what we have written, it means what it means. And then there's a DTI as well. I don't know where that, but I remember it's somewhere. Where did I put that one? I don't know where it is. But we also got in the documents, there's also, no, it's here. The documents submitted intellectual companies and all that. We also look at that the certificate, according to the information on the certificate issued by companies and Intellectual Property Commission 23rd, shows that Oak Bay Limited is registered. What are the active directors? Then, in the policy framework, which is now 4.1, when this document comes to us, they tell us about what this law stipulates, so that minister doesn't approve this thing from vacuum. He must see what this is what the Act provides. And then it goes now to what is 59A, which we tell minister what it is. Then the recommendations now. It is therefore recommended that minister consider granting Mr. Gupta and family certificate of naturalization in terms of this, as we quoted all those things which are in that Act. Then based on that, that is the letter now, which is on K. That letter which is quoted in that submission was not even drafted by the minister. It's drafted by the officials. And now they explain now to them again about that. They have done that. Minister, in powers vested on her, decided to waive this. The issue now, Chair, is that if we've got a scale, I might have put those things in a scale, they carried a weight. Maybe to you, I put it on a scale, it doesn't carry a weight. But the decision maker applied his or her mind. In this case, the minister or the people who are in the group of the list, we applied our mind. And we looked at that and say it suffices. Now, let's come again now to that question which was asked. At what point do you renounce? Go to letter L. It says now, dear sir, declaration of renouncement of Indian citizenship, yourself and the family. You are hereby informed that your application for South African citizenship has been conditionally approved. It's not saying has been approved. Is conditionally approved. Eh? No, it's L. What's it then? Oh, I can't see the date again now. Yeah. No, but yeah, no, but the letter surely is written after that. Yeah, yeah. Okay, no, fine. No, let's continue. Yes, yeah. But where's the date stamp? We must check whether it doesn't have a date. Maybe it's a copy. So maybe in the date stamp we'll see it. Okay. You are informed that your application for subsistence has been conditional approved. You are kindly requested to submit the following in order to finalize the issuance of, but there's even a reference number, that the issuing of the citizenship certificate, proof of renunciation of your Indian citizenship. On receipt of these documents, you will be required to sign the declaration of allegiance, which we're talking about, after your South African citizenship will be finalized. This assurance of citizenship is valid for 6 months from the date of issue of this letter. So it means if they don't come back within that period of 6 months, then that process again will start again. Now, we go again now to, is what we were asking. Here is the people now who submit to us. What is there? So this is a Consulate General of India. They put what is their reference number there, 4763-2015. They've got a date, at least get them. And then they put what they are saying. And then that is for Mrs. Gupta. And then the other one is of the wife. The other one is of the son. The other one is of the son. And they quote their passport numbers and everything. Now, based on these things, now it means now Mr. Gupta has never renounced his naturalization. So Mr. A. Gupta is not been naturalized. Has not. Is still a permanent residence holder. The people who have been naturalized is these four. That's where now the certificate of naturalization can be issued. Then I'm coming to that question again now, which was asked, another step. If now we go to implementation of naturalization, Chair, then I want to go to point number 32, because that's where we are, which is a question which was asked by the honorable member. We are saying here, Chair, in terms of Section 59B of the Citizenship Act, the department is required to table names of those granted SA citizenship by naturalization to Parliament. We're saying that. What is the point? We're saying, the last report was submitted in 2012. I'm going to go through it. Annexure R. Since 2013, the department naturalized whatever. What is important is the point. It was an omission. That's what we're saying. We are saying we did not table that. But what we're going to look at, was it only Gupta family at the Minister Gigaba's time only when the department did not do that? That's what we're going to show. Let's go to S. No, R. We touch R. We are saying in R, on 16 January 2012, the Minister of Home Affairs tabled this. And then, number 2, the Minister of Home Affairs, a list of approved early naturalization applications for 2010 and 2011, terms of 5/9. And then from there, you go to the list. It gives the list of people who in 2010 were naturalized and give the list of people who were naturalized in 2011. So, Chair, that rule says you must table that within 14 days in the new opening of Parliament. If you look at this, it means now the 2011 ones were correct, but the 2010 were incorrect. They were tabled late. But read maybe that's why we'll deal maybe with legal to say the requirement is for tabling. It doesn't say, Chair, there is a condition that the Parliament must look at that and then says we are happy, therefore proceed. It's not a condition to grant the citizenship. It's the requirement that we table. That's why you are saying, for not tabling is not correct. That's what we're saying. We should have tabled this, but by not tabling, it can't be equal to the are null and void. But let's go get to the list so that now we see when did we said we last tabled in 2012. The first person on the list, which now were not tabled, is Mr. Jerome Walter Henry Falfelke. This person, Chair, was a Secretary General of FIFA. No, Annexure S. No, I'm taking you through. That's why I'm waiting for you. I'm not rushing. So the next one is a sports skills soccer. We remember we wanted to understand what those people are. This one, Mohammed, it owns a business. So Gupta family who applied to us, they own business. It's been done in 2012. And then after that, we approved Prevost James Castle was a marketing director. We approved Agula Vasco de Jesus Paradas is owning business. And then we approved Allah Black Ali. We even put their nationality, own business. Dino Gabrielier was approved, a pastor. Then the family of Gupta is here. Chair, I'm going to come back now on this issue that, and then the people who are here are only those because he is not here. Mr. J is only the four, which is the mother, the wife, and the son. And then Chada family, and Adenji family, Kalumbu family, and Duyan Kim and Welso Thomas. So, Chair, what this thing now means is that the previous ministers of Home Affairs, we have not tabled the approved naturalization from 2013, but it's for that list. That's what we'll be having to correct. But Chair, if you go to Annexure T, in particular again now with the Gupta family, why we use this? We received a parliamentary question from the Honorable Member Hussein in April of 2016. And he asked us whether his department issued citizenship to any members of certain family. And then, no, that one is not, I'm going to deal with the next one. We gave the names. They are there on that part. No, you don't have that one, Chair. It's going to be the second one. I got this one, but it was April, this one, 2016. Oh, okay. So what I'm saying here, Chair, is that by even responding on that question in April 2016, we're not hiding anything. It was there, we reported it. Then in October 2016 is the one I attached, number T. Again, Mr. Hussein asked the question. And then if you go to T, 1, 2, 3, 4, 5, based on, we even said with reference to his reply of question 1007 of 25th April 2016, what are the full details? Then we replied, what shall we said here in 2016 when we're recommending to Honorable Hussein is the same with what is in these documents. The reasons did not change, we explain it. So, Chairperson, there's nothing on this which we did not report. So, the issue now which we're saying is that we did not table that on that date, and when we did not table, I'm still saying, Chair, that's why I was saying it was not a right thing that we did not table, but we did not table only the 5 names, but the 5 names which were not tabled, we reported them in Parliament are there. And we gave the reasons, we gave the names. Chair, I think at that point again now, Chair, we are ready again now with my team to be able now to take questions of, and Chair, whatever, we'll be able to try and respond as a team. If there can be something we don't have, we will submit back to the committee if there's something we do not have.
Okay. No, thank you very much, DG. And honorable members, I think now we may be better off than before we started this meeting. And we should be able, we have got the tools now to actually talk to the things that have happened. And there is a declaration that, yes, it is not right not to table, which is being accepted, and with the intention to correct that. And then again is that it is not the Gupta family only that were not tabled, and it is not also related to one minister, it's a couple of ministers for the department that had that particular situation. We are having that. And then I think also the serious issue that needs to be, that we need not to miss, it is the workings of the department, as described by the DG as the bureaucracy. And then I think we have been taken on the process and how the documentation then started wherever they started until when the minister had just to exercise at the end to say, I agree and sign, I don't agree and sign. And then we have been taken right through that. That's why I'm saying is that I'm sure even our brothers and sisters, fathers and mothers and uncles and whoever that is actually have been listening to what I have been listening, we are better empowered now to be able to make our opinions. And if there is any other thing, I think at the time, I think Honorable Hussein wanted to ask something and Honorable Melder wanted to ask something for clarity. And then now I think we are in that now stage to say, what is that we don't understand? And then it gets clarified. And then if it is possible, we end up identifying anything that is of problem that the DG can't explain, it needs to be explained by somebody else. And then we convince each other and agree, or we fail to convince each other, we don't agree. That's the situation where we are sitting in now. Honorable Hussein, do you still want to speak? Steenhuisen. Yes. You still want to take that opportunity to raise what we wanted to raise when I said let's... Okay. In any way, it will be problematic for me because if I say you ask question for clarification first, so that all of you are on the same page, for when you start debating, then you have got similar understanding. And then we sometimes get into a debate, and then let's just open up all of it, and then we. Should I say welcome? Because I was not aware that you are here. It's long that you have been here, or you have just arrived. No, it's welcome. Thank you very much, and you are welcomed. And then let me take note of Honorable Steenhuisen. I think this will be number one, and then I'm not sure whether Honorable Mulder still wants to take the opportunity.
Yes, I do.
Yes, so you'll follow. And then I've seen Honorable Raputi raising a hand. I've seen. I thought that today then you were actually, and now you are just changing halfway. Okay, let me just indicate, so Honorable Raputi will be following. And then it was Honorable Mankomo that raised a hand before. And then Honorable Slopen then will then follow. Then, you know, I think you are 2 or 3 in the house. I usually confuse your names. One is from IFP, the other one I think is from COPE. I really can't differentiate you. It's Carter. Yes. It's Carter from COPE or IFP. It's COPE. Thank you very much. At least I know a little bit better now. And then Makenye, then
Jay,
you'll
thank
follow.
you. That's a compliment because Liesel van der Merwe is a lot younger than me. Thank you.
No. The manner in which you sometimes come up in the house is I almost see one person. But at least I'll pay attention now. Thank you very much. And then Honorable Kenyan then will come, and then is Mnisi, and then Kekana. And then Figland want to also to speak. Actually, it looks like I've noted all of you. Yes, I've noted all of you. Start from Steenhuisen. No. I start from Steenhuisen, and then in that order. Proceed, Honorable Steenhuisen.
Thank you, Chair. And let me repeat what I said earlier. Thank Mr. Plenny and his department for being here today to take us through the documentation. I'd like to turn firstly to Annexure I, if I may, which is in the documentation. It's a letter from Oak Bay. I see that you submitted the company details to both SARS and to the DTI and Oak Bay. But was any of the other claims made in it to the amounts that were referred to in paragraphs 2, 3, 4, and 5 subject to any further scrutiny or investigation to whether these were in fact true claims and the scale and nature of the claims made therein were accurate? And was this then the only document, apart from the documentation that we've seen prepared by Mr. Sikakane, that the Minister relied upon to make his decision to use this as an exceptional circumstance in terms of exercising his authority in terms of the Act? And I hear what you said about not knowing whose money and whether the husband and the wife, etc. But frankly, Mr. Plenny, I don't think it's applicable in this case. Because Oak Bay as itself, as we know the South African law, recognizes corporate entities as separate beings, separate creations, separate to the owners. That's why we have the term a corporate entity in our law. And those companies, therefore, are represented in law through company directors. And through your own checking, so your department's own checking, you've determined that the directors of the company in Oak Bay are a Mr. Nazim, who's not an applicant in this matter, Mr. Varun Gupta, who is an applicant, and Mr. Chala, who's not an applicant. So those are the 3 directors that you've determined, in terms of your own investigation, are the corporates responsible for the corporate entity that is Oak Bay. And so my first question to you, sir, is how you took a corporate entity and a corporate identity and applied it to applicants, in this instance Mrs. Gupta and others, who themselves are not company directors of Oak Bay Investments. I would suggest to you, sir, that their reliance on Oak Bay was an incorrect reliance because they were a separate entity. They weren't part of that corporate entity that is Oak Bay. They weren't even company directors. And so therefore, whatever Oak Bay's assets were should not have been taken into account in terms of any decision that Mr. Sikakane may have motivated in that regard. I then would like to turn to Annexure J, if I may, Mr. Chairperson, and that's the documentation prepared by Mr. Sikakane. And perhaps to understand what the reason was for the volte-face from the committee stage, which, as you confirmed to me earlier, had consistently applied the regulations as per making the decision, and had therefore come up with a rejection and recommended a rejection. So I'd like to understand how we went from a refusal from within the department to Mr. Sikakane now advancing a acceptal. Was it done on the basis of Annexure I? Because it seems to me, looking at his motivation, Annexure I seems to be the only reason why this should suddenly be a complete change from the applied, consistent practice of the committee to now motivating to his minister that there is a change. And so I'd also then like to ask you, sir, if you have on record, how many applications have you processed during 2016 that failed for not meeting the same requirements as these, the Gupta family's rejection was done? Do you have a figure on how many other applications were rejected by your department in the same calendar period for non-compliance with that same section? Mr. Apleni, I enjoyed every part of your presentation up until when you tried to explain away why there was a material non-compliance with the legislative prescripts to table in Parliament. I would suggest to you, sir, that that is a material requirement, and it's precisely done to ensure that there's proper parliamentary oversight and accountability. Your attempt to substitute a response to a parliamentary question for that accountability was very creative, sir, but I would suggest to you it doesn't go far enough in meeting the benchmark of ensuring that your department meets its requirements to account to Parliament in terms of its legislation. But again, Mr. Apleni, it's very difficult for me to hold you accountable for that, because as you indicated earlier, sir, that power and responsibility lies with the minister in terms of the legislation, and that has not been delegated. So it's impossible for me to hold you accountable for that today. I would also suggest, sir, that if one looks at the schedule that you've applied on Annexure S, I think it is. Yeah, Annexure S. I think what you look for in situations like this is outliers. And I would suggest to you, sir, that if you look at the number of exceptional circumstances, naturalizations that took place under both Minister Dlamini Zuma and Minister Pandor, looks like there were 2 in those calendar years. Minister Gagaba has 18 such naturalizations in a single calendar year. And I would ask you why what moved the benchmark? Why was there suddenly an outlier, a leap of the numbers of applications? And why is Minister Gagaba, did he lower the benchmark? Did he adopt a far more loose and fast approach to these naturalizations in terms of this thing? Because it certainly seems to me a very large jump from the calendar years prior of 2s to suddenly jump to 18. I would also say to you, sir, that using other names, including sportsmen and sports administrators, etc., given the current context in which we find ourselves, and it's very important to understand, sir, what the context of this inquiry and this investigation is. It relates to serious allegations of state capture that have emerged, and that's why parliamentary portfolio committees are applying their minds to it. And I would advance to you, sir, that Mr. Beeston Twabarira and others are not implicated in those emails. But the Gupta family and Minister Gagaba, both in his previous incarnation as Public Enterprises Minister and now as Home Affairs Minister, is implicated in these emails. And I hasten to add these allegations at this stage, but we must understand the context in which this meeting today is happening. And it's within that context, sir, that I must ask this question then as well, and I would ask a separate response from each of the gentlemen concerned. But whether you, sir, Mr. Mkhize, Mr. Sikakana, have ever A, met with the Gupta family on a one-on-one basis, or their representative, B, have any of you or your family received any material or hospitality benefit in relation to Mr. Gupta or his family? And whether it's, if you have, in this instance, was this declared in terms of the prescriptions of your code of conduct as civil servants? I'll leave it there for now. Thank you, Chair.
Yeah, Honourable Melder.
Are we going to take all the questions first, sir, before we get any answers?
Come again?
You want us to ask all the questions first?
Yeah, it's, if you have been covered, and then you just simply say so, and then if you would like to take a second bite when you come back as well, then you'll have an opportunity. Probably we can finish at 5 o'clock today. It's not a problem to me.
Thank you, Chairperson.
Proceed.
Thank you, Chairperson. The first question, Chairperson, I would like to ask the Director General is to tell us a little bit more about the tampering of the letter that you referred to. The date, the December 2015 and then later 2017 date. If you can give us more about that, please. Then we understand that the family applied as a group. And then the DG made the point, but if Mr. Gupta applied on his own, he would have qualified. But am I wrong if I say he could not apply on his own because in terms of the regulations, if they are minors and the family as a family, they have to apply in that way. That's why they did that. I beg your pardon? Thank you. Yes. Yes. Then I think we need to come back at some stage to section 5(1)(h). And that's the one that deals with the denouncement of your other citizenship, the Indian citizenship in this specific case. Because looking back now with hindsight, it's quite clear that Mr. Gupta himself was never going to denounce his citizenship. He hasn't done so up till today. And even in the schedules that you've attached, M, N, O, and P, with regard to the other 4 applications, there are indications from the consulate that if those applicants denounce their citizenship, they won't have a problem. What I would like to ask, have they denounced their citizenship? Has that actually happened in the other 4 cases? And if so, on what date? So have the department received basically now proof that those citizenship of India has now been denounced? And then I want to ask the DG, since then, have the Gupta family been issued with South African passports? And in that respect, are any of those official passports or not? Thank you.
I think I noted Honorable Raputi. Yes.
Yeah, thank you very much, DG, for giving us that outline. And really, we can see that there are systems in place in your department, and we applaud that. And I believe that there is no one who is perfect in life. The person who is perfect, I think he's sick. We stated categorically last week that authenticity of documents is of paramount importance. And DG, during your presentation, you said that there are some letters that were altered, information that is not really authentic. And I'm really, really worried about that. It shows that there are people out there who are desperate, misleading, wasting even our people out there with wrong information, with information that is not authentic. And if we can really assist us, we really agree that yes, people must be whistleblowers, but they must not mislead. They must not mislead the country. And really, if ever we want inquiry in that information that was falsified. It cannot be. It is totally irresponsible because people want to gain some political gains here. We cannot come here and mislead our government, make our government ungovernable because of wrong information. And that they give other people to come and really want to have some political gains. People must be able to know the right and the wrongs. But we can see that now something is totally wrong. Somebody is taking out information to the wrong people, and then they come and jump and dive here. I think it's irresponsible. And on the issue of Annexure C, because we want proper data on Annexure S, DG, that is Annexure S, which doesn't have date. I think that one, we really need proper kind of a date because it has a reference, but there is no date. If we can really get the date properly. But we cannot, people cannot come here and mislead our country that is so peaceful. I thank you.
Thank you very much. And Ms. Mankom was next.
Thank you, Chairperson. I think thank you, DG, for your information. May I start off, Chairperson, by letters which are not dated. Whilst we may be saying to ourselves that could have been an omission, it could be viewed quite seriously. As a result, we would like that to be corrected as soon as possible, and then we get an understanding of what actually happened. Secondly, the numbers which the minister, Honorable Kigaba, I think there's about 18 people that has managed to give permission and, approved things through the very bureaucrats that have given him the information. I think, Chairperson, I would like to make a humble request, which may not come in today. Chairperson, if one were to ask that we look at the previous ministers of Home Affairs from 1994 right up to date, who has actually given out large numbers of people like 18 instead of the 2, the 1, and whatever? Because, it does not seem to be correct. The third question is that whilst we do take note that Mama Gupta and the wife and the children have all been given naturalization and everything else, AJ, right throughout our media, he seemed to be quite influential in a lot of these matters. And that is what our investigation will need to look at quite seriously. We do understand that he hasn't taken his citizenship and all that, but we need to say to ourselves, let us look at each case and look at its merits and then come up with the finality of the actual matter. Lastly, I must thank the DG for the information, although I must state, DG, that I'm a bit worried when it comes to dates and everything of that nature, which actually clearly show that things are not okay, and you know, letters which are not authentic. We will definitely get to the bottom of the matter. We will investigate and get to the bottom of the matter. Thanks, Chair.
Thank you very much. Is Shope? Where is she?
I'm here.
Oh, proceed.
It's just because you call me Shope Mkalipi. Okay, thank you, Chair. First of all, I just want to get a clarity. That's why I wanted to speak first before the questions comes. On Annexure S, DG, on Annexure S, I need a clarity on that Annexure S because, DG, in front of us here, the first letter from the department, it talks about 5 people as a family who applied for this naturalization. But when you go to Annexure S, I see only 3 names. So now I just want to get a clarity, who has been naturalized, who has not been naturalized. That is one. Secondly, DG, you talk about the omission. Okay, let me just go to Annexure S again. The committee was sent a naturalized person names were tabled in Parliament since 2012, but there's no records for that. It's just a listing. So there's no evidence that you have submitted.
Just a second, Honorable Shope. You made reference to Annexure S.
Yes.
And then you seen 3 names.
Yes.
You see SS right at the top. The 4th one. 7.4. Do you see?
Yes.
Do you have double S?
Yes.
Yeah, double S on top, then you've got 7.4. I think it's a continuation of the Gupta family.
So Suyakant is a Gupta family?
It's 4 names.
Oh, Suyakant.
And we have been told that they applied being 5, but only 4 were naturalized.
Lord, wait, Chair.
Okay, you may proceed.
So Usuyakant, if is the 4th name, is Suyakant. Usuyakant in this letter is number 2. Is that correct?
Two sons. 2 sons is Singala, Kamal, Khan, and Surya Khan. Those 2 are the sons. The mother is woman, and then
Why?
so there are 4. So that number is correct.
Okay, I will just,
Okay.
I'll come back
Proceed.
to it. Yeah. So you'll clarify that, DG, because we need to know now how many people I was speaking about who have been given this early naturalization. You just have to be clear on that one. Okay, it's all of them, 4, except the 5th one. Okay, what happened to the 5th one? No, okay. No, it's fine. So I just want to also get a clarity on this one. On the omission side, ne? So DG, you took your time, you explained everything, justifying that all processes. Can I just speak freely here? Because I don't disturb anyone. So justifying that all processes were followed until the 14 days. The report was not tabled in Parliament. And you have been saying this thing where the minister, the current Minister of Home Affairs, she was saying on the media as well. So I just want to check if, are we on the same page? If these 14 days, which were supposed to be followed in terms of your procedures when you're quoting the Act, was not followed, it means that the procedures were not followed correctly. So those people who have been given the early naturalization are here illegally in South Africa. I can see the DG is saying no. Oh, okay. Oh, okay. No, it's fine, Chair. And Chair, we would like to get a very clear indication or an explanation from the DG about that omission thing, because we don't want to conclude here. The reason why you didn't table that report as required by the law within 14 days, you are not hiding anything. You can't follow all procedures correctly so. And then you fail on one thing, which is Parliament. And then the department come and tell us it's an omission. We need a clear explanation on that one. But I want also just to emphasize the point that if all procedures were not followed, it means that those who have been granted, who are for, are here illegally. And I would also like to hear from the department what are they going to do about them, because they are here illegally in the country. Because I think it has been a week when I saw the DG also going on press talking about Mahlangu of Satao, correctly so. He was here illegally and the department acted. So I just want to understand if this law only applies to certain people, not to other people. There's two. Now, whereby I just want to get a clarity, because the DG is justifying that the minister did not act alone in terms of section 0.5.9 that empowers the minister. The minister also got from you as a department, and then you have alluded to the fact it's Kakane and others and Kize. So now, whereby I have a problem, DG, you as the DG of the department, you correctly so said to the Guptas, please reapply again. You even given a date. I'm not sure about those dates that are conflicting now, 2015 and 2016. But the point that I'm making, you have followed all procedures as the department through adjudication committee, and you declined their application because they were not following the procedures and the laws of the country. And now, when the minister wants to grant the Gupta's family this early naturalization, you are saying your department have advised the minister. So it's not a contradiction, because I find it very, very, very skewed. You even pointed to them to say, please reapply again in the state. But when there is an appeal now from the Gupta side, you turn against your decision to say, no, we are advising you, Minister, just to grant them. Are we not contradicting ourselves as a department? And then the Honorable John Steenhuisen have asked a specific question to say to those gentlemen, did they meet Guptas? I want just to put a different question to you, gentlemen, because we are also leading this department. When you took those decisions, that decision that you advised the minister to grant the early naturalization of Guptas, you were not told by the minister to say, please change your mind, give these reasons in order for me to be covered? Are you not covering for the minister? I'll pause from there, Chair. I'll continue.
Honorable members, I think sometimes I am accused of defending the department, but you sometimes create a problem to me when you ask a question that has been clarified clearly, and then we put the question as if nothing has been said. I think that I would like us to make sure that we listen very carefully. If the issue that you had has been clarified, then there must be a level of acceptance that there is this information they've said and we have had it. And because, thank you very much. The one that follows is Carter. I think it's Carter, and then it will be Kenya. Then it will be Dambuza, Figland, and Gumede. Mnisi, you'll come after Carter, and then you'll be followed by Kekana.
Okay, Thank you, Chairperson. Chair, firstly, I just want to start more with a statement, in that the statement that was made on the emission. I think, firstly, we must not just sit here and decide that an emission was simply, and that the requirements were simply for tabling. We have a responsibility as members of Parliament to have an oversight role, and that is the bottom line. So that emission, just simply for tabling purposes, is totally wrong. I would like to get a point of clarity on especially number L, where it says conditionally approved. Can we define the requirements of what was the conditions? There must be some conditions set for the conditional approval.
Should one interject, honourable members? I think this is now the situation that is going to be a little bit painful, because that's exactly where we started. Probably we're not here. And we spend a lot of time on that, on the legal requirements. We spend a lot of time without speaking to anything else. We spoke to the law, what the law says, and all those conditions were clarified before we got into this next session. And therefore, all these people here, they know the conditions except you.
Chair?
Do you accept that arriving late then may
I would accept it, but it's
problem?
not that I did not. I actually followed
Yes.
it. I followed the process before I came here. But I was busy with other things while I watched it on the parliamentary channel, and then I made my way here. And specifically, when I came in here, we just started going through the actual sections.
Yeah, let us not argue. I'm trying
Okay.
to say to you, all these people that are here, they know that we started on the law, and it was explained, and the requirements for approval and the rest. All of that the DG explained, and then we even opened for questions of clarity on the law itself. And then it was exhausted. Then we agreed now that we go to the process.
Well, my question is going to lead into the next one, so we can leave that one.
Okay, proceed.
Okay. So, taking into consideration what I've just asked, if we go further and we go to, we look at, where was it now? If we look at the requirements for tabling, Sorry, Chair. If we look at section M, N, O, and P, okay, it says clearly there that the Guptas should then surrender their Indian passports, okay?
I am having trouble with the connection.
That was Siri, okay? And so if we look at M, N, O, and P, it says that the Indian passports need to be surrendered, okay? So if we are saying here that there was a conditional approval, but then the question is, did they actually surrender their passports? Because I'm just thinking as a person, and this is on clarity, okay? Yeah. As a person, if there's a condition to me getting naturalisation, am I really going to go and surrender my passports? So I think it's, if we can just get there, did they eventually then surrender their passports, then I suppose we would that way would get to it. What is also of concern is, okay, Honourable Steenhuisen covered me on the corporate entities, but my next one is, if we have a look at 2013, Nkosazana Dlamini Zuma approved 2, 2014 Minister Pandor approved 2, and in 2016 we seem to be having a free-for-all with 18. Can we just, and I would also like to get clarity, even if it's not in this session, but how many in total applications were received, how many has been rejected, and how many has been approved? Thank you, Chair.
Thank you very much. Honourable members, when you speak, try to speak to the mic, because we have just simply been conscientized that it is being broadcast live, and there are problems of getting the sound. Then can we try and speak to the mic, and then we can proceed. Mamnis.
Thank you very much, Chairperson. Chairperson, there is a letter here dated 2016, it's October 2016, by our Honourable Member Hussein, which shows that this matter is not coming for the first time. Same question we asked and answer, and all answers were provided by the department. So Honorable Hussein even went to the media during the weekend with the same information before coming to the committee meeting. It seems as if there is nothing new, Chairperson, that we are doing now or that we are doing today. It's a matter of repetition of one and the same thing. Neutralization, Chairperson, is not new, and the Guptas family were not the first one to be neutralized. We've seen a letter with all the names of people that were neutralized. That were naturalized. Yes, thank you. It's very bad now, Chairperson, because our portfolio committee meeting is now used as a campaigning platform by our opposition members. And really, we don't like that. So I also, Chairperson, want to check from the DG.
Point of order, Chairperson.
Allow her to speak.
No, I'd like a point of order, Chair.
I'm sorry, Chair.
No, I'm sorry.
There is a lady here behind us. She is also interjecting. I don't know, this lady here.
Can we allow Honorable Mnisi to finish her
Chair, I'd like to
input?
take a point of order in terms of the rules of Parliament.
Allow her to finish her input.
Sorry, Chairperson, a point
Allow
of order.
her to finish her
A point of order
input.
takes preference over a member speaking.
No, allow her to finish her input.
Are you going to let me take my point of order then when she's concluded?
You will take that point of order or whatever. Allow her to speak. No. Honorable Steenhuisen, you will remember that you were the first to speak. And you spoke. Nobody,
For a long time.
nobody interjected. No, fine. Allow her to speak.
Yeah,
Thank you very much,
Chair.
Before, Chair, can you please allow this woman? I don't know. She is also participating. She is also in supporting what is honorable is saying there. That honorable. So I'm asking, please tell her not to be part of the discussion.
Okay. I think that point has been made clear, even if I've not repeated it. Those that are not honorable members, I think they know they can't participate. And then I would like Honorable Mnisi to complete as.
Thank you.
Can we allow Honorable Mnisi to complete?
No, it was just a...
I would have loved that Honorable Mnisi complete her input first.
Thank you very much, Chairperson.
And then
I'm not...
By that lady, that was the point I'm making.
Yeah.
That is the point I'm making.
The lady is quiet.
Yeah, I think she has learned a lesson. I think. Can we allow Honorable Minister to complete the input?
Thank you very much, Chairperson. I'm not sure if I've attacked anyone because I've got a letter here, which is a proof that the same question was asked several times before. So this is the proof of what I'm saying. And also, Chairperson, I just want to check from the DG whether the minister adhered to all the procedure. Also, whether the minister acted according to law, which step that needed to be taken and whether not taken by the minister regarding this specific issue. And my last question, Chair, is also on that one of tempering letters and change of dates. Please clarify that, DG. Thank you very much.
Thank you very much. And do you still want to say what you wanted to say? You may proceed.
Chairperson, may I just congratulate you on the mature way in which you've chaired this meeting to date. But Chairperson, Rule 85 is very clear that you may not impute improper motives to any other member or cast personal reflections on that member's integrity or dignity. I'm not here to campaign. I'm here to do the job that the Constitution said that I must do. And I don't think it's correct. I also think it's very important to determine that parliamentary questions and responses thereto are given to individual members, not parties. We're all individual members of this House. The fact that Hussein got an answer to something doesn't necessarily mean that I must be simply regarded as having been answered to. I'm here to ask questions, as is my right and duty as a Member of Parliament, and I'm entitled to do so without being subject to attacks on integrity and dignity of us trying to do our work.
Thank you very much. And I'm not sure whether I have not heard her properly, but if I thought that I heard her properly, she referred to the DA. She referred to the DA, not directly to Steenhuisen, not directly. And I'm sure we have got many rulings in the House on that particular matter. And I think we must just go, let it go. And Honorable Kenya.
Thank you, Chairperson. I think my two questions has been taken. Protection, please, Chairperson. When somebody was talking, I didn't even speak. I just kept quiet and listened. I think Honorable members just listen to me.
Honorable members, I think we have been performing very well when we started. And I think we should continue as such and behave ourselves. One doesn't need to call honorable members to order as if we are school young boys. No. We are senior members representing others. And I really have noticed that the questions that you ask, you are really empowering the citizens you represent for the answers to come out and them being empowered. Let's continue in that particular manner because it was an honorable manner that we have conducted ourselves. And then let's allow the remaining members that wants to speak freely and to complete their input without interjection. Honorable Kenya.
Thank you, Chairperson. My two questions have been asked, but I don't know whether it's a question, maybe, yes, it is a question, this one is a question. DG, you talked about, on the document, né? I think on JJ, there's a background there that talks to what has been done, that talks to the background given. I just want to check that motivation of a person if, let me look at it first. Maybe I'm okay. That talks to 2.6, to Mr. Chawla's motivation. Given proof, yes, of course, we don't have any proof of documentation that talks to that. Maybe those have been, what have been done to in your outreach program. You said that you go and see yourself. So just want to check, did you ever go to Northwest to check if those people have been really assisted? And also, have you checked that the 7,000 employees are there, they are permanent, they have got those permanent jobs? Because I think, to my understanding, that is one of the motivation that led to the Guptas to getting to be here. The 75 schools which are given sports kids clothing and equipment in Northwest, and also the 50,000 people is on I think it's a feeding scheme, and school uniforms, etc., and then the 7,000 permanent employees. In your outreach program, did you ever see that had happened? Secondly, on JJJ, under policy framework and implications, I'm concerned about, yes, maybe the issue also that you enter and that tells if you are intent to continue to reside in the Republic of South Africa, you must enter to continue services in government. Yes, maybe that also what I was asking, that relates to what I've been asking. On G, also under policy framework, JJJ. Now, it is said that the person must have adequate knowledge of responsibilities and privileges of South African citizenship. My question is that, how do you measure that person? How do that person is measured that really she has the knowledge of responsibilities of the privileges of the South Africans? Okay, I think, I also concerned about the letter which is also, that talks to proof of renewation of the Indian citizenship, noting what we asked on about maybe just, yes, of course I can see that if it can be dated, because now it makes us have to have confusion, because on 2015 we have that letter from the Consulate General of India, according to one of the letters, that talks to this proof of negotiations, talking to the same issue we asked at first about the renewation, the allowance, the proof of renewation, the letter of renouncing your citizenship of the. Now it's not clear whether this proof, because to my understanding there must be something that talks to this proof of negotiation of the Indian citizenship. What happened to it on the Guptas? Thank you, sir.
Honorable KK.
Chair, let me not waste time. I'm happy. Let me start by saying that DG, thanks very much for your presentation. I just want to touch on 3 matters only. And I believe that Mengomo spoke about it, but I just want to make it clear. There are 2 letters that are questionable, DG. One, you said, or maybe you claim that it was altered. That one needs to be investigated. And then number 2, without a date, I think, Chairperson, it needs to be investigated again. And why I'm speaking about investigation, I don't believe that DG, for now, is in position to clarify us about these letters. Then we must know what is happening. Number 2, the issue of tabling these persons in Parliament. I heard DG talking to it very painfully. At some stage trying to say to us that is not so much important requirement. I think, as he even said to us, that is the responsibility of the minister. This question alone now gives us a grip to get the minister to tell us more about this thing. We should not run away from the problems, and we should not water the problems. We must take them head on until we get the truth. And lastly, I wanted to know if Department of Home Affairs has ever or sometimes done business with the Guptas. I thank you, Chair.
Yeah. You want to take the second bite?
I'm the last
Shouldn't I allow Honorable Gumede to speak and Honorable Dambuza?
Maravale, I'm the last one.
Yes. Yes, and then Honorable Dambuza.
Chair, thank you very much. I'm not going to take much because most of my questions have been exhausted. But I think that question of being providing the jobs and so on and so on, that investment that they have done, I think it is very critical, DG. Although you are you are saying that you did check from the DTI, they are there, but I think you need to do a lot and not in investigation so that you bring a concrete report for us. Then the other issue, Chair, UDG, she talked about during the legislation part of it, when we were discussing the legislation, he talked about the signing of an oath on the what is this, renunciation? Yes. But I want to check if those people who have been given the naturalization, who have been granted the naturalization, have they signed that oath? Because if I'm looking at this, it's only a letter from the consulate, but we don't see a stage where they sign the oath, because I believe the person who's responsible for the oath, it's me who has been given the naturalization, not the consulate. So that's my point, Chair. The other one, the last one, Chair, I would urge UDG to be fair to us. To be fair to us. Once a legislation is there, it has got to be implemented. If there are gaps in the legislation, it's their responsibility to ensure that they advise Parliament that we do have gaps in the implementation of this legislation. But now you cannot say now, in your defense now at this current time, present time, to say, no, it was an omission. Now I was a nurse. I was told that you are responsible for your acts and omissions. I was told that. So, chairperson, if I've made a mistake, I'm responsible for it. So I'm trying to say, DG, I'm just trying to be fair on your side. Don't defend this matter. Rather, let's discuss it and then come up with a amicable solution. Otherwise, that is an omission, that is the breach of the law. Because if it says the law, within 14 days, it must be brought before Parliament. It does not change. You know that. Even in your reports or annual reports, you make sure that that period, stipulated period, you run, because you know that you have to submit your reports to Parliament. I'm just trying to be fair to you. Let's just make it very easy. Let's not make this to be complicated. Thank you, Chair.
Honorable Gumede.
Thank you very much. Thank you very much, Honorable Chairperson. Honorable Chairperson, I think there are two issues that have been stated by colleagues before. That is the issue of the date stamp. I think there should be there should, if the non-clarity is because we did not get a colored copy, because perhaps it's just a question of color, I don't know. If it is there in the original copy, perhaps we may make it out. But otherwise, in administrative processes, there is correspondence in, correspondence out, and so forth. I think we can make out the date around which it has happened. The second issue is the issue of tabling. The issue of tabling, as has been said, it is a question of compliance and then recognizing Parliament as well. But the question arises, did the non-tabling affect the decision, or was it a process issue? To me, it looks like it is a process issue, imported as it was, but it does not have any materiality of whether the decision was going to get to the right or to the left. So, but I still I still insist that it is necessary, and the department has to submit these. But I also take note of the fact that it is not the only one. Therefore, it was, I tend to interpret it as a question of oversight or negligence rather than a corrupt act. And combined with the issue that all these cases came before the Chief Justice of North Gauteng, the court, that significantly affects the materiality of the transgression. It's a transgression, but the materiality has been minimized by its being submitted to the judge president of the North Gauteng. So generally, I would say that I'm satisfied that the department had followed due process, but we still need that letter with a date stamp or proof that it was signed on that date. And secondly, there has to be an undertaking that in future we are going to have all required processes submitted to Parliament on time and always. And if that has not happened, there should be consequences to people along the line, depending on the delegation of authority in the department. But generally, I think there is due process. There was due process in this instance. Thank you very much.
Okay. Thank you very much. And I think we have raised a lot of questions to the DG, and I hope that is still capable, because during his interview, I think he was asked whether he can work under pressure, and he said yes. And then probably the pressure that comes to bear on him would not actually derail him. Probably, I think, on the letter that you said, there is a falsification. If there is any explanation of the date that you wrote in there, what informed that date, probably it can assist members to understand what is wrong between the 2015 and 2017, if there is any explanation. And yeah, proceed. No, you have got no right to be confused. We'll help you. Thank you. Proceed.
Sorry, it's just in terms of, I think I completely misunderstood what Mr. Pleni said about the role of Judge Dustin Mlambo of the North Gauteng High Court. My understanding of his role was that he simply swore the people in as naturalized citizens, but it certainly wasn't subject to a legal review. Is that right? Because I'm not aware of a case that appeared in the North Gauteng High Court in this matter.
I think he will explain that, because there is one of the requirements on the conditions, I think, that speaks to what is allegiance and blah, blah, blah. But that, I think, is knowledge of whatever of the... Yeah, he will explain to you. I think there shouldn't be a problem. DG?
No, thanks, Chair.
You may be hungry, but proceed.
Yeah, thanks, Chair, and as well as the questions which we have received to members, we'll try again and clarify. Chair, I think let's start with your last question, the letter, which we have circulated. This letter is not from me. It was circulated in the media. That's why now we get it on that. What is this thing which is sent to it? What was that? This thing which is running on it. There were two letters. It was the one of 30th plus this letter. If you look at this letter, Chair, look at the bottom of it. If you look at the stamp, the letter we have, it goes, if you look at this thing says now, date, look at Tlachwayo. Upon our letter, it is on the A, which is Annexure D. And then on this one, it is on the W. Do you see that stamp? Annexure D. Do you see that? It's not my letter. It's the letter which is circulating on the media. 2, this letter, it says, however, you and your family will qualify to reapply on the 23rd December 2015. But our letter says 2017. And I've explained, Chair, that the reason why it is 2017 is because another member is short of 2 years to complete the cycle. Do you understand that? So if somebody, but the issue for me is to say, this thing is what has been circulating in the media, and we're saying this thing is not what we have. No, this letter is on the, what I'm saying is that when we were, remember there were 2 letters, when we were called to explain this, there were 2 letters which were circulating in the media, social media said, the Hlachwayo disapprove the granting. Minister approve it. But what I'm saying to the committee is that this letter which is on the social media is not the letter which we have as a department, but I'm picking it on the social media that I can't know if the guys can get the date. That's what I'm talking about.
If this letter was in the social media, but I got it from my documents, from the department. That is why I say it is important for the DG to make an investigation with it in department, because those I didn't get it from any social media. It came out from my documents I read last week. The first document, it is there, Chair. Not this one. Not this one. The fact I didn't get it to the media. I want to correct that. I did not get it from the media. I got it from the documents that were circulated, the first documents. So I think DG must check from the department, how did it come to us? I'm not talking about social media. Nah.
We never circulated a document. Our first document we circulated to the committee is this one.
Honorable members, the DG has circulated this paper now. He says this is the document that was in the media, that was actually probably circulated by the EFF. This one. No. In the media. The DG has just printed it now from that social media and gave to us to show that the date at the bottom of 2015 is not the same as the date that he has in the record of 2017. No, honorable members. Put your hands down. Put your hands down. Put your hands down. The DG has given us a letter which he knows, and now the letter is in contrast with the one that was in the social media. He is explaining what he said, that the date of 2017 has been falsified to 2015 on the letter that is in the social media. And it is not the letter that he knows with that date. He gave us the letter that he knows. That is the one that we're having, and that is the one that you are asking for a date or whatever. So we have these 2. It is our business now to argue amongst ourselves whatever the story is. But he has actually told us what is a genuine letter from his office. And you can't say he's lying when he gives you his version. And then it is up to us what we do after that. I would have loved us to allow him to answer the questions. I would have loved him to continue and respond. We now know that there are 2 letters with 2 dates. We know it's the information that we require, and then we should be a little bit fine with that. Let him complete the answers.
Just
I'm
a
making
second.
plea.
To say that let's get the authenticity of this letter so that we'll be able to deal with all the other the assumptions and whatsoever.
Let me ask that the
Let us agree that this letter must be investigated. We will find the authenticity. We will know exactly where it comes from. Let us not assume all of us, because this one will blame this one will blame this one. We are adults enough. Let us investigate this letter. Why are we running away from investigation? Yeah. Then it will be another question to Aplane, and you'll find that Aplane is right. You'll find that it was forged somewhere. Let us investigate this letter. Then we'll get the authenticity of the letter.
Honorable members, let me intervene. I'm saying the DG has given us a letter that he thinks is authentic, comes from his office. In the media, we have got a letter with different numbers. It is now in us. I said this is not the last meeting. It's not the last meeting. And then if this particular matter requires further processing, we will process it. But let's hear the version. That's why I wanted the DG to tell us what they know best. And now they are telling us what they know. And then it is up to us to think whatever we are thinking and about any other thing. Let's allow the DG to finish the answers. Proceed, DG.
Thanks, Chair. Chair, let's move, but we'll try now to combine these questions where we can. Chair, the first questions were asking whether figures are subject to scrutiny. Yes, Chair, that's why now we says people, remember I said, the committee which deals with the issues must verify these things. That's why they went to SARS. They went to DTI. They go wherever. So they must verify it. And now here, Chair, now we couldn't bring all that file. But if you want to, we'll bring all them and say, here is a SARS certificate. Here is this. But the fact of the matter, these things must be checked. That's why there is a committee. That's why now in the same report I'm reading to you, I'm saying SARS said this one said that. So the figures has to be verified. And then, Chair, in issue of whether there are other documents, yes, in the file, there will be documents which now, if you want the whole file, and then we can bring it and say, here are the files which we have done. Chair, let's come to this thing of whether is a corporate and all. Chair, we give you a naturalization. One of it here is the CEO of Coca-Cola. He's not owning Coca-Cola. He's not. He's just working there. But because he's working for an institution which contributes to our economy, yeah, let's go to a list. That's why if you want that, we will be able to bring, I'll give you an example. And that's why I said other people are business. Yeah. Kalumba number 11.1. On Annexure SS. Annexure SS. Number 11.1, Kalumbu family. Kalumbu is a Zimbabwean. What is doing there is a president of Coca-Cola, is a managing director. Did I consider now the worth of Coca-Cola? I did not. But what we did, that's why I'm saying, we are given, Chair, that authority is given to us. We have applied our mind. That's why I said, in you, you might think that, hey, that does not count. But I'm telling you what we considered. I'm saying here in the list, I've got a managing director who is of, is not even only Hanangomye Ucha Chanda Arun, number 9.1. Now he's an executive director. So what I'm saying is that when we consider this, not only one item and one aspect, like now member says, no, we must go now and check the numbers. We can go. These businesses are there. Surely they are registered, even about Department of Labor, all what they need to comply with. But we did go and check at SARS and check, because the main issue at that point is to say, is this business paying tax? Because it's like we do on the tender side and check. But we have checked that and say, but what I don't want is to say the only consideration which we did, we considered all the facts which were in front of us in that matter. And it's not only on that one. We've got, as we've given you a list, which is what is said now, that from 2000 and 1994, we'll go back and look at who has been naturalized and all that. That information should be there. Then we'll bring it. But if now, that's why I'm saying when we tabled it, which comes now back to this question, I've never said, maybe I didn't communicate it properly. I've never said the non-tabling of the report is not an issue. That's why it is in my document. I put it here. When I was writing this thing in June, if I was taking it as nothing, I wouldn't put it in my report. But I put it and say this, and I can't come and lie and said I did table. Because I'm taking this matter serious, then I lie to the committee and say, it's a fact. It can't change. We did not table on those dates. Now the question which is asked, why I did not table, I'm saying there was no malice on our part to say we're hiding something. Because I'm saying that if it was only in the 2015, when Minister Gigaba was there and approving the Gupta, then that can say to us, why have you been tabling all these years and not only table this family, then that is going to be a problem. In the same year, which the members are saying here, to say we have approved others, what about the others which were not tabled? And again, honorable members, it can't be correct to say if people are in that they are illegal, as the honorable member was saying. It's two different things. Those people obtained the ID book fraudulently. These ones here, we have given you what was the process followed. And the legal people are here. We checked this thing to say the non-tabling is incorrect, but it can't be equal to that the people, because they didn't do part on this thing, starting from John Welker, Mohammed, Prevost, and all them. It's not them who said, I need to meet this requirement. So what you have given me, we have done it wrongly, therefore I don't qualify. If we can do that with my little understanding, those people challenge us and say, your non-tabling can't be equal that my application, which I've done correctly, and as not unless we were saying the approval process is wrong, then that will mean something. But we are not saying that. We are saying every process, which is what I was listening to, up to that stage is correct. There's nothing we did not do. The only failure which we had, which we have admitted on it, is that we did not table. Members are not getting that from anywhere except in the document which I submitted to say I did not submit. But if I did not submit in the same document, I say we will then submit. So I've never said submission, I'm taking light, is not an issue. I am an accounting officer. Those things are not written for nothing. It's for a purpose. But what I'm saying, reading the same section, it doesn't say either that the parliament must rectify. That is another issue. If that thing you read, it was saying, before you give the naturalization, you must go to parliament and parliament rectify and thereafter you action it. It's not saying that. That's why I'm saying in 2012, the same submission which we have here, it was 2010 naturalization and 2011. The ones which were correct were 2011 because them, even that one, I don't think, maybe we submitted within 14 days. But the 2010 were late. 2010 were late, did not comply with that regulations. but the Parliament received them. We never received a report from Parliament saying to us, you have tabled this thing in 2012, 2010 is incorrect, you must do this. So I think, Chair, we admitted, and we will never come here and lie to Parliament. I couldn't say, because I want to cover up or something, I must say, no, I've tabled. I did not. And I've explained it in my document, which I've signed for it. I've signed for it and say, I last tabled in 2012. After that, I gave members the names of who were done after that. And after that, I've said, we will table. We're going to come to Parliament and table. If it's a late tabling, we will submit and deal with the issue that we have submitted late. Then, Chair, the point of that, I had Honorable Stayhazen about the issue that a parliamentary question just go to the member. It's fine. But what is the moral of the story with that is to say, we in April 2016, when we were asked by Parliament, did you grant Gupta family citizenship on exemption, not on anything else? Then we responded and say yes. If we were hiding, why would we have done that? And then again in October 2016, comes back again to us and say, give us the reasons. Why did you do that? The reasons which are in that parliamentary question of 2016 is the same with what we're giving it now. If the intention was to hide anything about not tabling, why would we have done that? We wouldn't have done it. So the issue here is that we have accepted, that's why I've put it. Maybe get the wrong word, maybe was to say an omission. Maybe I should have said is a failure. If that was going to be the right word, maybe I used the wrong word to say there was an omission, but the bottom line of it was just to simply say, we did not table. But in the list, which the committee members are talking about, it's not only Gupta, it's even saying there are 18 people. So why would we choose them and then hide others? And again, it's not only when Minister Gekaba was there. We are saying during Minister Pando's time, we did not table. During Minister Zuma's time, though we did in 2012, but after that we did not. So that thing, we're trying to say it fall into a crack. That's why, Chair, why we want to deal with these matters. Sometimes we're taking responsibility. Home Affairs must modernize, because this paper thing, that somebody does the paper there and then this thing get lost. But if we can have a system, it will tell you about this and that has not happened, but that's what we're dealing with. Okay, let me move, Chair. How do you move from rejection to approval? Chair, I've explained it. I'm saying the courts of this country, why do they move from not approval and change it? Why are we not asking that question? No, it's different courts. No, but now it's different. That's why we're saying that is the committee. That committee looks at it and they decline it. But they explain why did they decline it. They say, we have declined because these people did not meet the number of days in the residence. It's not hidden. It tells what it is. But they're exercising the right which is in the law. Now, it looks like now then somebody, I heard the honorable member said, we said to the Guptas must reapply. No, the Guptas exercise the right which is in the statute. Like anybody else, that's why I said to you, the waiver or whatever is not only in the civics regime. I sit with people who apply for a business permit, we declined it, for whatever at a particular level, then they appeal. That's why we've got an appeals unit. Why do we have appeals unit? It's because circumstances can point out that there is an issue. I know one of the regulations which was problematic, Chair, we declare people undesirable and said will never come to this country until it's 5 years. When that decision, what the rights people have, they go and then appeal. That's what is done. Then he was asking now, how many other applicants rejected on this list? Is the one which you are going through it. Here, on Anessa SS. No, they were rejected at, they get an exemption. No. No.
Let us just allow the DG to finish. Because
the question was, how many other applicants in the 2016 which have been rejected, which now Minister Gigaba or whoever minister will be there would have put that. So I'm saying the people have been rejected on that score. Remember, let me explain this again. Yeah? No, but I'm reading your question.
Honorable Steenhuisen, I'm pleading. Just hold on a little bit. Just hold on a little bit, because what we are understanding is that you have got a list of naturalization. And what the DG is saying is that these people also, they have gone through that particular route until they succeed on the minister exercising his executive powers. That's what he's trying to say. But let's allow him, whether the answer is very nice or not nice.
Take it.
Let him finish. Let him finish.
Chairperson,
yeah, you may have an opportunity.
Yes.
Okay, sure.
Can we explain, Chair, again? Chairperson, I said. Can you, Honorable Steenhuisen, explain to you again? We said, I even use a word. Yes, okay, yeah. I said, Chair, when I was explaining, maybe I was not understood. I even used a word that is like you graduate. Chairperson, that's why, if you remember, in our white paper for migration, one of the things which we are proposing there is to say, remove this thing of graduation to say, I've got my temporal residence permit 5 years, I've got my permanent residence for 5 years, therefore I must be naturalized. We're saying delink this so that you are in our country for 10 years or 20 years should not allow you to graduate to being a citizenship only on the basis of the number of years which you are here. That is the proposal in our white paper. So what it means is that anyone who has got 5 years here and have applied for naturalization, they've got it. If now you can ask me how many number of people have naturalized in 2016, in 2015, and there you don't even look at what this thing which you are looking at it on exemption. Are you adding value into the country? Are you whatever? The simple thing, it just says, I've been here for 5 years, my time now has come, give me a naturalization. That's what it has. That's why in the white paper, again, I was saying, no, delink this as permanent residence to naturalization so that you can be in our country for 50 years, but must not be equal to that you must get citizenship. That's why now when that question was asked, how many has been rejected? It means now it's these ones. Because when now it was rejected, then they applied again now for that rule, and then again now they were granted. However, we can go back and check that, but I wanted to explain to you the principle. Let's come to check the other one. Then now it says now 6. Chair, let me explain the number, but there is no rule which says, Chair, you must grant 5 or you must grant 20. It's based on what are the people applying for. And as I'm saying that, we can go back, because, Chair, remember, this is South Africa. Is a democratic country and has got I can't just reject your application when you made it just solely on the basis that, hey, now I'm coming past my number. I must apply my mind, because if that person takes me to court, I can't argue and say, no, I did not look at this exemption because it was gonna pass the number of 10 or 20. The fact is, how many people have applied? How did I apply my mind on them? And then are the reasons. The only thing we should look at is the reasons for granting those valid and they can stand the test. But as I said, that will give that number. And again, it is important because I don't want this 18 as this 18 people. It's the families. That now this family is looked as one, it's got these numbers. But when we come that, we can come with other numbers of the families which were granted before. Then, Chair, I don't know. I mean, I can't use what Honorable is saying, that no people are implicated on emails and all that. That can't be the basis of a department which is given a mandate statutorily to implement. And I go to the gossips which I'm getting everywhere. I can't. I must apply what is in front of me and I test it. If it is correct, it is correct. Then now, have I ever been in Guptas? I can only respond for myself. I can't respond for other people. Colleagues are here. I've never been. I've never been in the Guptas. I've never had any business with them. I've never received any gift with them. No, nothing. I don't have that. But I can't speak. Maybe the colleagues here, when they are for that one, they will respond for them. I mean, I don't want to do that. Then now, I think, Honorable Mulder, we have dealt with this issue of the tempered document. I've explained that. That document, I don't know is what I've got it from the media. I've looked at it, but I was just telling you what mina I have. That's all. Then now, you were saying if family, they are minors. But you remember, that's what I've done when I was presenting. I said, no, these two sons are not minors. I said the Surya, I even mentioned that one. I said the young one, who's Mr. Surya Shingala, was born in 1995. At the time he was applying, was already 18 years. So there were no minors in this application. That's what I was saying, that applying in the family, yes, if they were minors, they would be under their parents, but they could have applied individually. But in this case, we are saying they did apply as a family, but it was not based on the fact that they did not meet the requirement A. Where is that one? To say you must be, where is that thing now? He or she is not a minor. So these two were not the minors anyway, but they applied as a family.
Hold on, leave the DG to complete the answering.
But may I just say something? The problem is, then we're going to go back to each and every question. I want to assist this DG that we can complete the question. So I just want to correct him in one instance, and then we can dispense of that question. Because if you're going to do that now, we're going to go back to each and every question at the end.
Okay. Do it.
Fine. No. it's with
but I'm doing it under duress.
Sure.
Continue.
With regard to the dates, the only difference in those two letters are the date change from 2015 to 2017. That's the only difference. Why would somebody do that? No, you didn't do it. I accept that the letter of 2017 is the official letter of the department. I accept that. Somebody changed the letter to 2015, and that's in the social media. The question from a legal point of view is, why would somebody do that? In terms of what change will that make to the law and the process? That's just a separate issue. With regard to the children, Chairperson, I'm referring the DG to paragraph 11 of his own memorandum, the one he gave us right in the beginning of the documentation. Paragraph 11. What does paragraph 11 say? It says, furthermore, if the applicants for naturalization have children, it doesn't say minor children, have children, or dependents, mother or father, there's a mother now that applied, they must apply as a family. Now,
speak to the mic.
Sure.
No, DG, sure. DG, just press the button in front of you.
Okay, then, let me start. Okay, no, you are right. Let me start, Honorable. You see, I can't sit here as a teacher of Home Affairs and start knowing what were the intention of the people who did that. Because once I start that, I'm speculating. And I'll be giving you a version which I wanted to suit my case if I've got a case. So I don't want to get that. The only thing I'm saying to you is that why our letter was saying 2017 is that one of the family members was shot with 2 years in order to qualify. That other person changed it to 15 or whatever. I am not knowing why it did that or what is the purpose. So I don't want to get that. What I'm saying is that the letter, which was running on the social media, this letter was not put by me. I got it from I don't know even by who circulated. I don't want to get it because once I start, that means I know about the letter. I don't know. But what I was explaining is that. Coming again now to, let's go now to.
Just a second, DG. Probably, I'm sure Honorable Melder will see that the problem he has caused me. Now I can't stop Honorable Shope.
Yes.
Then now, yeah, you see, that's the challenge that honorable members must assist me to maybe direct the meeting so that we get to finality. But I mean, it's not nice to keep on saying, no, honorable members, no, don't speak, wait until this one. I'm saying it many times, then I think even in the public, I look like, I'm actually micromanaging you and you are making it difficult for me to run the meeting. But you can assist me. We have asked questions, then I think I've been repeated. And then before the DG started answering, then we'll say, let's allow the DG. The response that he give may not be 100% as you require it or complete as you require it, or it may be having an element that you still have a question on it. But allow him to give you that answer incomplete. That's what I was pleading. But I ended up being defeated. And I don't want to be defeated continually. I want to recover. Can I allow the DG to continue and complete?
Okay, on one point, Chair. If you want to allow the DG, we don't have a problem. It's just that you have break your own rules. We have said, let us allow the DG. And then when Honorable Mulder come in, you allow him. So, wait, Chair, wait. And then Honorable Mulder, when he spoke about the letter, that way we want to respond as well, because we have something to say on the letter. Unless, if you, Chair, you are saying, it's fine, if we still have to raise that thing after the DG, we can respect that and do that at the end of the day.
Yeah, but honorable members, let me repeat this. The DG has got his letter that he can vouch that it is his letter. Then we have got another letter that looks like it, but it's not 100%. And it is not his letter. He says it's the one that comes from the meeting. That is the information for us. You can't make him to answer for a letter that it is in the social media, which he says he doesn't know. It is up to us to actually try and find where that particular letter comes from. The other one we know we're going to get it from him, from his file. Let us not make him to answer for mischievous things according to him. That is happening somewhere else.
Chair, with due respect.
Yes, and then that's why now I was saying to Honorable Mulder, then say, I'm allowing you under duress.
With due respect, Chair.
Can you proceed with your question, Honorable Member?
Don't micromanage me. I'm saying with due respect.
Yes.
The issue of the letter, you can't complete the issue of the letter without giving EFF. Because we also said, you, Chair, this letter is the EFF letter. So now, I must respond. I'm not saying the DG must accept that letter. You must hear me out what I want to say about the letter, Chair. I think it's only fair. It's not fair, Chair?
Proceed.
Okay. Chair, because now we have allowed Honorable Mulder to speak about the letter.
Then Carter is going to speak as well because now I've allowed you.
Yeah, it's fine.
And then Steenhuisen wants to continue.
Chair, but we would like to speak as
well.
He's
having his hand up.
It's fine. You break your own rules. It's you who break your own rules. So you must set your own rules.
No, Honorable Member.
No, we like to respect you. But if you keep on breaking your own rules, what must we do? I
may have broken my own rules under pressure from Honorable Melder, but I have made it very clear to him that I'm allowing you under duress. But then you did not listen that allowance that I've given him, I have done so, but not necessarily willingly. And you should have actually picked it up that Honorable Mulder has actually forced me to allow him to speak. But now, if you wanted to piggyback on that, you can proceed piggyback. But I'm saying it is up to you as honorable members to assist me to conduct the meeting and make sure that the meeting gets to an end. But if you want it not to come to an end, it is also in your power, because very soon I'll be told that, no, I'm suppressing you not to speak. You see? But you also have a responsibility there, that you don't just keep us here endlessly. Proceed, Honorable Hlophe and Honorable Carter and Honorable Steenhuisen.
Okay, I just want to say on the letter, DG, you are confirming the one of 2017. And for this committee, it's just to say we accept your letter because you are confirming it. The one that was circulated in the social media, let us not accept it because it still has to be investigated. If EFF still have evidence that the 2015 is the correct one, EFF will come back. But for now, for the sake of proceeding, Chair, let us accept the 2017 one. But also, Chair, it also raised eyebrows. I think the 2015 one, if the date was correctly so, was 2015, it was going to at least to say to the department, oh, 2015 in January and 2015 in December, at least the decision that was taken by minister, it informs about the very same year. So now we have to raise questions, why you were rushing to take the decision and rush for 2017?
Honorable
It's
Carter.
even complicate things, Chair.
Honorable Carter.
Thank you, Chair. I was actually just wanting to help you as well, to say, listen, we know that there's a lot of fake media out there. Let us accept the 2017 one, because if you look at the actual letter, this wasn't a photocopy that was being amended. Someone within the department, because the stamp, everything is not on the same level. Someone in the department forged it and forged the signature, and therefore there should be an investigation into it. But I agree, let us forget about the fake ones now if we are told that that's the correct one and continue.
Is Honorable Steenhuisen accommodated?
I'm not worrying about the fake news. I just want to understand from you process, because my follow-up question was denied, whether I'm going to have an opportunity when the DG is finished to come back to him, because I think there's been a willful misunderstanding of my question. Am I going to be given that opportunity?
Proceed.
No, at the end, I'm happy for him to finish. I'd like to know whether, when he's completed, I can come back to that question.
No, you can raise it now if it is on the matter that is already answered, for him to include in the answering.
So you're letting me press rewind?
Yeah, proceed.
Great. Thank you, Chairperson. Chairperson, I want to go back to this list that's before us. The DG has not, and I don't know whether he's deliberately misunderstood my question or whether he's playing politics. This was not my question. These are applications that have been approved. You'll see column 3, 4, 1, 2, 3, 4, approved.
Yes.
There's not a single one on there that says rejected.
Yes.
So what we have before here is a table of approvals. That was not my question.
Yeah.
My question was how many that are not appearing on this list where an appeal was put in, but that appeal was rejected. That was my question.
Fine. But
I said if we want that information, we can check, but I've explained it. So we'll bring it. Come again? So must I just think what you're going to ask?
No, Honorable Steenhuisen. That is not the information that we requested.
Chairperson, people must come prepared for meetings.
Order, Honorable
Missing
Steenhuisen.
half the file. He hasn't brought half the file to back up the first question.
Honorable Steenhuisen.
That is the reason Hussein is not here, because this honorable DA member,
hold on.
he wants to do this.
Hold
please,
on.
Mr. Easterhuizen, can you
hold on.
please don't bully us? Don't bully us.
Hold on. Honorable members, don't do what you are doing. Don't do what you are doing. And then there is a set of documents that we requested last week from the department. And this information that we're talking about on SS or whatever, we did not even ask for it. Yes, but I mean, the level of preparedness is a subjective matter. You know, you can't say that there is a document that indicates when are you properly prepared or not properly prepared? And then I think is that we must accept if there is any information that we don't have, and then we must make arrangements how we can get it, rather than actually making somebody run. Okay? And then shouldn't we allow the DG to complete
Yes, no, I wanted to propose that we give DG a chance to finish and respond before maybe if you've got another bite for another questions then, instead of making these dialogues.
All right. I'll proceed, DG.
No, thanks, Chair. But Chair, I must comment on the matter by Honorable Carter to say the letter has been forged by the officials of the Department of Home Affairs. Chair, that is completely incorrect. Not unless he can give me an evidence for that, and then I will go and deal with that staff member. But if it doesn't, it mustn't cast aspersion to the staff of the Department of Home Affairs unfairly. Thanks, Chair. Let's move. Now, Chair, have they denounced the citizenship? Chair, how this thing works, as we're saying now, the information we have seen is what we got from the embassy, and then it says now they must now surrender their Indian passport, and after it not say before, because it's what I was explaining, to say you can't be stateless. So now after that, then that's what, because the Indian does not recognize the dual citizenship. So, Chair, that's what information we have. But if we need a further information, as you said, we'll go and get that further information which you need. Then, Chair, around the passport, really, I can't sit here and say they've got, but what I know, they don't have an official passport, but I don't, because official passport is only for a person who is an official of government. But whether or not they've applied for a passport or not is something which we can check. But they have the passport, can give you that info. But they've got a right. I think that is the important thing to say. The right is there for them to apply. That's why we said the only right now which they have acquired in addition to what they had before was the right to vote. But even at a permanent residence level, you have got a right to apply for a passport. Yes, Chair. Then, Chair, there was this issue now about Judge Lambo. No, Lambo, as I said, it started on this one. You know, it's a ceremony. This has got nothing to do with approval. But what we wanted to do is what other countries they do. In order for people to take seriously the issue of being a citizen of another country, we said we were just giving them letters. And then it ends that signing that letter of allegiance. Then we felt that, no, let's do it differently. They must go in front of a judge. They must do that so that at least to them, there will always be this thing to say, hey, on the day I was naturalized, this is what has happened. So it started only on the 2016. Honorable Rapport, I think we have dealt with your question. Chair, we will look at this thing of a letter without a date. Surely, as we said that, maybe it was a photocopier, maybe there is not, maybe it's like that, but we'll look at it. It's not, and it's one letter. It's not all the letters, Honorable Ngoma. It's that letter of saying declaration of renunciation yourself and family. Maybe we can track even, because there is even a reference number there, 153111. So it means it's a document which has been issued by us. So we can check that. Then we'll look at this thing of from 1994. And Chair, you know, I was faced with a case again of a person who was naturalized in this country. Wanus Walus. I'm sure we remember his case. Yes. Wanus is the one who killed Comrade Chris Hani. Was naturalized in this country. No, but the issue is we can't be selective on this thing of naturalization. So we will bring those lists and say, here was naturalized, but this is what he committed in our country. And that, can we say now, no, because Yena is Wanus Walus, there was something, that's why I'm saying that, so Chair, once we get into that one, it makes us a little bit emotional. because those people, that person was naturalized in this country. Okay, let's move, Chair. But I wanted to deal with the previous people. And then, Chair, as I've indicated, to say, Honorable, that AJ is influential. As I'm saying, for us, we deal with the principles of the law. That's why we accept where we didn't follow that, because now we can't be influenced by all the other things. Then I think I've explained now on the, you asked me this question of I think, Honorable, I did explain the issue of omission, you remember, and then now the 14 days, and then now you asked me an important question to say, is there anything which you are hiding on this? Then I'm saying no, because the law, as we said, that is not the only family, and we will table. And that reason which we were giving to the committee today, which was given to Honorable Hussein, is the same reason. We can't change it. It's what we had. So we will submit and tape. But there was nothing which we're doing to hide and not doing that. I think I clarified, get the number 4. And then I did say that they were not illegal in our country, as they've got a permanent residence and all that. And I've explained that they were not reapplying, but they were exercising their right, which is within the law. Then I think, Honorable Carter, is the same thing which we were asking about. What was this condition? We have explained that the condition which they have to meet was the one that they must denounce their citizenship. That was the condition which was put on that. And then I've already responded again on the issue that if MNO and N were to bring a document now from the India Commission, we will do that. And then it's the same question again now, which I understood now from Honorable to say how many approved and rejected. We said we'll bring that. And then Honorable Miss, I think to you, wanted to check, was saying we have followed all the procedures according to the law as we have explained. The only thing which we did not do was to table the report, that's all. And then, Honorable Kenya, as we said, we checked those things in our way that we are checking. But again, in the fact, because we check a thing in a particular way and all that, and so. But I don't think they can any doubt to us to say, but that family, if now I've got something from SARS and I've got something from DTI to say they've invested in these businesses, I cannot be able now to but again, we will check anything which we need to check. And again, as you said, which is an important thing, to say checking these things must be, as I'm saying, as a department, we look at something to say, can't be say we're only doing it to them, but it's a lesson to say, guys, going forward, do this, and then in certain intervals, maybe you check if now this thing has happened, and all those processes we will be able to build in order to improve our processes. I think, Honorable Kekan, I did respond. And then you on the issues of the letters and the tabling, I've explained this thing, but it's very important to us. Home Affairs, no, we don't have. I think we've been getting a number of parliamentary questions around this. I remember one of those with that, with the they've got that, which now they NN7, together with, they will have those media issues. We never paid a cent as a department. Those questions were asked, but we're going to the platform, but not paying in. So Department of Home Affairs has never done that. Then, Honorable, so what I'm saying now that those proof of investment, we use what we have, and then now with the oath I've explained, and I know it was only after, and then if the legislation there are issues, yes, that is our responsibility to come to the committee and say this, we can't do it, but we don't think we cannot be able to meet the requirement of tabling. It's not a difficult thing, so we won't want it to be amended, but we'll comply with it. Then Honorable Kumet, I think yours were more. That is the issue of the letter which we said we'll do. And as we have said, that I support what we are saying, that the report was not tabled. It can nullify what we have in terms of the processes, but we will make sure that we table within a space of no time. So, Chair, I hope that I've tried.
You have tried, and then also I think one question that was asked by Okata was a proof that they have surrendered their passports. Surely that should be answered by the Indian embassy, because they will surrender to the Indian.
Yes, that's why I reported that we'll go and check.
Yes.
Yeah.
Yes. Honorable members, I think you have done very well, even though that there were interjection of weaknesses, but we have performed very well. What the department knows about naturalization in general and about the Gupta family naturalization, we do have, and we have received it. We do have that knowledge very clearly, how it has been done and how it is done, and we have got all the information. All what may be left may be political decisions or influences which surely we can't get from them, like as others have said before. But in terms of the law, or maybe one should start at this point, is all of us, I think we have taken an oath at the beginning to actually pay allegiance to all our constitution as well as all our laws. And this Citizenship Act, it is one of them. The Immigration Act is one of them. And we are part of the state. And the department is actually naturalized people on our behalf. Actually, on our behalf. You see, in terms of our act. And then now is that there are issues that the DG has promised to give to yourselves, and then information. And of course, like as I've said, is that this will not necessarily be the last meeting. And then actually the question that we have now is to clarify the issue of a date on a letter. I think that's the one matter that is actually outstanding. But then the issue of not tabling is an issue that is being accepted, and also that it has not happened. And also they say it is not the only family that theirs was not tabled. And then they are going to correct that. I think we know that. And what else is outstanding? That needs, of course, is that I think the other thing that we should not miss is that thing that the DG described as bureaucracy. That you are almost the department that prepares almost everything, even the recommendations and everything to the minister, if the minister has to exercise his right. And we had the processes, how it is done, and we have got all the information in front of us. What else, over and above that letter of a date, and also the number of those that were rejected. And then I think it's even promising to find out whether they have surrendered their passport, the 4. But do we really just need the 4? Or is it all those that have been naturalized but not yet tabled? I think you must then clear your minds, and then so that when they come with information that these 4 have done that, then we ask about the Nigerian. Then it will not be cohesive with our thinking and processes. So it's so that it goes back and it's very clear that what to go and verify whether they have surrendered their passport. And yeah, what else is left? Let me start with Carter.
Chair, maybe I'm out of order.
Yes,
Okay,
I hope that we are not going to have speeches.
No,
You're just going to say this.
Yeah, no, there was one specific item that Honourable Steenhuisen that he raised, and that was the benefit of any other of the members. That was not, none of them has addressed that, and I think that is just an important one. I hope I'm not duplicating what he was going to ask.
Okay. No, it's fine, and then Sope?
Yeah, Chair, I just want to emphasize on my point earlier on regarding the letter that you said it was circulated by EFF with the date of 2015. I just want to say that the investigation is needed because if you remember very well, the minister on the 13th of June, the minister didn't deny that letter. He said those letters who are circulating in the media are correct. It's there on the statement. So now, Imama, please. So now, the DG is saying different things to a minister. So it's there in black and white from the minister's office that is accepting those things. So this thing must be investigated. Who is talking the truth between the DG and the minister regarding the letter that was circulated?
No. We don't need to move that way.
Why?
We don't need to move that way. You see. We don't need to move that way. Let's accept that the DG has got a letter, then you have a different letter, and then the DG is not accepting the letter that you had, and then that letter needs to be investigated. But the other question that is actually is in front of us, who must investigate it? Because the DG has got his own letter that he says, this is authentic, this is what is in my file. You have a letter, and then you know where you got the letter and how you got it, and then that is where we should probably we must get clarity how the letter has been received by yourself. That doesn't look the same as what the DG says is the letter. We will definitely need, and if we have to go a little bit further, and get some sort of a presentation from your side, how the letter has been received by yourself, so that then it can be traced back to the DG, to the DG's office or not, and declared that it is a creation or not creation. So that matter needs, of course, to be followed up. Yes. And then, can I get to Honourable Steenhuisen?
Thank you, Chairperson. Apart from the information that you've mentioned already, including that list,
yes.
I've two other items which arose from Mr. Plenny's presentation, and that's the full list of the documents used by the Minister to make his decision. He said there was a big file of them. Because I asked about Annexure I, and he said, no, this wasn't the only document used. So I'd like to see the other documentation that was used. And then the documents that were used to verify the claims that were made in Annexure I. I think that the honourable member in front of me also raised some concerns about how those were verified. So if we would just be able to understand what documentation, because SARS can't, with respect, tell you how many kids have had KFC and whether in fact 75 schools in the Northwest region have been supported, etc. So all the claims made in Annexure I, what documents were used to verify those and what processes were used to verify those. And then to just say that, I mean, I think that that Mr. Plenny's taken us up to a point, but I think that the next step in the process is to now, it's the final step, which is the Minister exercising his discretion. And I still think it's important that we have the Minister appearing before us so that we can, particularly once we've got those documents, we're able to then hold the Minister accountable for that exercise of the executive authority that he's done in executing the final step in the process, because I don't think we've closed the door just yet. To say that, I think that this also will depend on what other information comes to light. So Mr. Plenny's reluctant to talk about the context, but the truth is there's more emails coming out, and I've no doubt that there will be more involving this department that emerge.
Yeah, the question that you need the whole file. I think we'll definitely have to really make sense out of it. Honourable Melder.
Yes, thank you, Chairperson. We've made progress. I think all of us understand the process better, and we've got some information, but there are some things that we still need. Because in terms of what the department gave us in terms of documentation, there may be some other stuff and other correspondence that are not reflected in the document. For example, we were instructed by the House Chair of Parliament, Honourable Cedric Frolick, to specifically look into the relevant emails involved. During last week's meeting, I made that point. I said that we've now been instructed by the House Chair to look into all relevant emails that may have a bearing on the Department of Home Affairs and specifically in this regard. At the Chiefs Forum last Wednesday, it was discussed, and Honourable Frolick made it very clear that he liaised with the legal department, with the committee section, etc., and that it was decided that 4 departments have been identified for this purpose, Home Affairs being one of them. For example, we've asked, and it became clear today that Annexure I played a very important role because that's the letter written on behalf of the Gupta family to have an application in terms of Section 5(9) so that they can be re-looked into the whole question. That's Annexure I. And that annexure, that letter written by Mr. Chwala on behalf of Oak Bay and on behalf of the family is dated the 29th of April 2015. But there's an email dated on the same day, the 29th of April, and it's alleged that that email is being written by an official of the department, Ndifalani Dombo. I don't know if Mr. or Mrs. Dombo is present at the moment. And if you look at the content of that email, it tells and instructs, basically, given the direction to Mr. Chwala, exactly what should be contained in his letter. It's there. And if you read the letter of the 29th of April, it follows that instruction in the email. So all I'm saying, Chairperson, is...
Should you not have assisted us in photocopying that we have the document, all of us?
Chairperson, no.
Just like other things, because you are making us to swim in the pool, because the emails that we are speaking to now is the email that the EFF said, this is what we got from the emails. And that is what actually prompted Frolick to say there is this email that talks to these particular documents from Home Affairs. Sure. Look at it. But now you've got another email that we don't have.
Yes, there may be some more.
Because remember that ourselves, we have not received emails. Myself, I've not received emails. And then if you have an email there, it would have been much, much more appropriate to actually make sure that you send it to me. I would have photocopied it much the same as the letter of Honorable Hussein, so that members can have a view on that particular document. They would have actually spoken to it. But now, you are engaging us now, but we don't have that document. Whether it is correct that the email you are talking to there, it says the things that you are saying. We just don't know. You are making life difficult for the rest of us. I would suggest that don't even continue speaking about that email. Make it available. Then if we make it available to him, he will photocopy it to the rest of the members. When we get to the next meeting, then we will further speak to it.
Chairperson, I don't want to make it difficult. I want to assist.
Yeah.
Today, the department gave us information from the official point of view in terms of the process in the department. I respect that, I understand that, and it assisted all of us. But prior to this, we've been instructed by the House Chair to look also into emails that may be relevant. Okay? I understand that the DG may not have those emails. But those emails are somewhere in the public domain at the moment. I'm not saying that the DG will have the emails. They are somewhere out there, and many of them have been released. So our instruction is to also look into emails that may be relevant. I don't have all of them. I don't. No. So all I'm saying is that part of our investigation in this process goes beyond only the information that the department can give, and we have to look into that. So if you say what is outstanding, I would suggest that everything relevant with regard to emails, whatever they may be, are still outstanding.
Honorable Raputi.
Mr. Mulder, I think you've got law. And we did argue about the letter that was not really admissible here. And now that was not admissible, that was really falsified. And now you want to bring the emails that are going to be also falsified. So I think the issues of the emails is another issue. Please, Chairperson, can we really finish because it was not admissible, the letter we argued. Now you want to bring other things that are not going to be admissible. As a lawyer, no, thank you.
No, honorable members, I think we must not misrepresent things. Can I just read you the letter that came from Honorable Frolic to myself as the chair of this committee? It says, it is written to my attention, allegations of state capture in organs of state. I am sure that you are aware of numerous allegations of state capture that have appeared in the media in recent weeks. Some of these allegations involve the former Minister of Home Affairs in the granting of citizenship to non-South Africans. I would like to request that your committee investigate the allegations within the parameters of the rules and report any findings where applicable to the National Assembly as a matter of urgency. Then it is signed by Frolic. Then now is the version that you are actually putting today. Then it has got a lot of modifications. Yes.
Not at all, Chairperson. Whoa.
I'm just requesting that make that email of yours available to the secretary.
Yes.
Then it gets circulated to members. Then when you speak to it, anybody speaking to it, then all of us will be on par. And again is that we may even seek the department to explain themselves who is the writer, and then so that when we come and speak, and then we get their response on it.
Yes.
Thank you very much.
Chairperson, no, I want to assist you. It seems that we are on completely different pages. Can you please read again the letter that you've received from the Honourable House Chair? And then I want to understand what the House Chair says, because the way I understand that letter means...
Order now. Order, Chairperson.
Well, the letter I've read it.
Yes. Well, okay. Let me.
And then I think even
I request a point
even
of
last
order,
week I've actually circulated copies to all of you. You all have the copy of the letter. Thank you very much, Honourable Gumede.
Thank you very much, Honourable Chairperson. My point of order is that now we are wandering into other areas. We have been called to this meeting mainly for item 3. And item 3 is briefing by the Ministers of Home Affairs, Finance and DG of the Department of Home Affairs on the naturalization of the Gupta family. We have heard now the department has accounted on all the allegations. We have stated our dissatisfaction in some other areas. We have accepted some. So really now I think people are optimizing on the propaganda value of the surname of Gupta for purposes of campaign. Thank you.
Yeah, I think I would request that the honourable members, we get close to the end of this meeting. We have done, I think, what we are supposed to do. Anyone that has got any further information from wherever the source of emails is, then if there is any relevant email, send it to the secretary so that all of us should be privy on the information that we debate upon. You know, I'm just worried that Honourable Melder kept that particular email he's speaking to since morning to himself, you see. And then he let us speak
Chair,
about...
Can I please assist you?
No, just a second. Just a second. Otherwise, you'll have to come here and then I come and sit where you are. Just hold on. And then I'm saying that I have confirmed right at the beginning that we may not be having the last meeting. Honourable members must understand that. And today we wanted information because some of us were not on the same level as you are, those that have got access to those particular emails and other documents. We're not on the same level. And the department has brought us to now the same level. But it looks like Honourable Melder is on a higher level again, which means now he must assist us to come to his level. by actually making that particular piece of paper available. And then so that when we come in the next meeting, then we are able to actually engage on a matter. And also we'll have sought the department's response, whether they know that email or they don't know it, the authenticity of it. Then because that is very important, I'm sure, having seen a document with 2 days, but that looks almost the same. And then it sends a message that we may not be dealing with an authentic email there. But I'm not saying so now. I'm saying there are questions. Make it available, let us do the processing, and then we make sure that we engage and finalize. And then I think those are the things that I wanted to say. And of course is that I thought I reached this point after you spoke, Honorable Steenhuisen. You still want to speak again?
I just want to make 2 points, Chair. The first is that I'm still waiting for a response from the other 2 gentlemen involved around whether they've met the Guptas, whether they've had hospitality from the Guptas, or whether, in fact, there's been a material benefit. Only Mr. Apleni has responded to that question, and he did indicate the other gentleman would. But also just to say, Chairperson, that I think whether I can understand your difficulty. I understand your difficulty, yes, because you don't have the emails. And I don't think the fault is Mr. Mulder's or anyone else's. I think House Chair Frolick should have submitted those emails to you, because if you look at the press statement issued by Parliament last week, it says parliamentary investigation into alleged state capture emails. And Mr. Frolick goes at length to say that how concerned they are about the emails, etc. I think that where the error has happened here is that you have not been provided with the emails. But I'm happy to help you, Chair. I have a full copy of them, and I will submit them to you through Mr. Hussain. But unless we investigate those emails, this process is a sham. We're not investigating to the full mandate that Parliament wanted us to do. Then this becomes a cover-up, not an investigation.
Honorable members, all I'm saying is that if you've got an email that is relevant to this, he says the granting of citizenship to non-South Africans, make it available. Because we are not privy, we are not recipients of emails. There are those in our society that had the luxury of receiving emails and then in tranches, but it's not everyone. Even Frolick speak about emails in the media, you see. So all what I'm asking is that if you have got any other email, make it available to actually make your point, but make it available to us so that we debate on the same level. And then I think that is all what we are saying. Honorable Sope.
Chair, I understand your difficulties now, but I just want to point out to you to say that I also sit in the Chief Whips Forum, and I understand that you are not part of the Chief Whips Forum.
I'm not.
Yes, so that's why we are not on the same page. What is the Honorable Mulder and Honorable John Steenhuisen is trying to say is to say that in the Chief Whips Forum, there's a decision that was taken there before even the letters from Honorable Frolick, because the DA have suggested to put an ad hoc committee on the state capture. And Honorable Frolick says no. Let us go back to our committees and deal with each and every issue that emanates from emails. Our understanding from the Chief Whips Forum is to say, Honorable Frolick have directed you as one of the committee members of Home Affairs that are implicated on the emails to say, please continue with these issues. Because this one is the first one about the naturalization of the Guptas. The second one is the spy on CIC, Trevor Manuel, and so on. That Home Affairs is implicated. There are more that has to come. So I'm saying, Chair, let us plan this thing better. I'm suggesting that you must go back to Honorable Frolick and ask him, because our understanding is that Home Affairs need to come back about those details. There are letters that are also alleged that the advisor of the former minister, Tamim Somi, were writing to HR of the Home Affairs. So all those things, our understanding is that they still have to come before this committee, because according to Honorable Frolick, it must be investigated, Chair. But Chair, let me just continue by saying that My understanding is that we have not concluded on this matter that we are debating today, or we are tabling today, because we still need a finance minister who is a former minister to come and answer some. Can I just finish, please? Yes, she's very rude. Chair, I'm saying my understanding, I just want to test your understanding as the chair, because we must summarize. My understanding, we have not finished about this matter, because today we just received DG's presentation. We still have to get a presentation or the finance minister to come here, because that 14 days, which is stipulated very clear on the Citizenship Act 5.9, that said within 14 days, the minister must declare in parliament, the minister must come. Because now I don't want to go back. One of my questions was not answered. I asked the gentlemen who said they have advised the minister to take a different approach on the matter, while the adjudication committee have turned them down. I asked them have you not been lobbied by the minister?
Who's that gentleman?
Those gentlemen, Kakane, who were just listed by the DG, they have not replied. I asked clarifying, I wanted to be clarified on the matter. Annexure S, I said it's just a list. There's no evidence to those things were tabled. Those things are not unpacked in this committee, but I'm saying, Chair, it's fine, because this is not the last meeting. We are still going to get an opportunity to ask, because the fact of the matter is the political decision that was taken by the minister on this matter now. And if we come back as Home Affairs, we are going to ask those questions to the minister himself. Thank you, Chair.
Thank you very much. Let me just reiterate this. We will await Honorable Froelich to give another instruction on any other matter. This one is in relation with the granting of citizenship. Any other thing is not part of what Froelich expected this committee to do through me. No. And then I think, honorable members, I have actually indicated that we have moved very fast, but we are all hungry, I can guess. And then, honorable gentlemen, is there anyone that wants to respond to the question of freebies or something? And can you respond if you...
Thank you, Chair. Myself as Richard Skakane, I have no relations with the Gupta family. I don't even know them. I've never met them. I only know them on paper in terms of the applications. Thank you, Chair.
Thank you very much, and that's it. The committee chair, Chief Director.
Yes.
Okay.
Thank you, Honorable. I only know the applicants through the adjudication committee, and I have not met them personally. Thank you.
Okay. All right. No.
The minister has not influenced us, me, myself.
No, Honorable Sobe.
It's very rude.
No. You are actually senior persons in this country, but we can't behave that way. And again, as well, is that you can't do that to officials of the department. We can't do that because they don't have the laxity of behaving like us to do that to us. Then we need to then respect this relationship, that when you need information, you get the information, but you don't make some insinuation, because it is not going to be correct. Honorable members, I think this brings us to the end of this meeting. And then a further meeting will be organized where further information that is in the hands of the DG that's going to come to us. And then also, of course, is that even the Minister of Home Affairs will be there. It will be an ordinary meeting. I think they will be there. And if we will actually also ensure that the Minister of Finance comes, because there are those that are actually pursuing that he comes. But all what I just wanted to indicate is, honorable members, let us conduct our work in the professional manner with objectivity. We should not be seen as if we are hell-bent to find fault, because then it will actually undermine our work big time. Objectivity, we have got a law that has been used, and then the law has been used, and then we have to actually evaluate the use of that law, and then those that need the minister, the political head, to come here and ask politics, you ask those politics, and then and get the answers. But you need to be very clear that in terms of the law, and then up to now we are very clear that they have followed the law until that they just did not table that certificate of naturalization, and then which is being accepted, no jiga, no manga business, is accepted that it has not been done, and we have got a commitment for that to be corrected. But then we will have the engagement with the politicians. We'll have them. And if that particular email that Melder is speaking about, it comes through here, we'll forward it back to the department, and then they will put flesh to it, whether they know it, whether they don't know it, whether it's genuine or not genuine, and then we'll get that particular answer together with the rest when we come in the next session. This meeting stands adjourned. Thank you very much.